necessary to speed up, firstly, the remaining compensation payments, and secondly, the legislation to quash all convictions, and we stand ready to support and work with the Minister on that.
Thank Noble Lord for that, and I can confirm that as far as parliamentary business is concerned, it's planned to have the legislation go through both houses and have it all done by the summer recess. So that is in process, and more announcements to follow shortly. In relation to the claims, as I said before, 78% of claims are now settled, and compensation has been paid to 93% of postmasters on some on an interim basis. As I said in the Chamber last week, we can only go as fast as we receive the claims. We're at the most difficult end of the claims now, and for example, in the GLO, the 477, we've had 58 claims, of which we've settled 41. We can only go as fast as the claims come in, and we have guaranteed that we will work to get 90% clear within 40 working days.
My Lords, I declare
my interest as a member of the Horizon Compensation Advisory Board. I'm troubled by the answer my noble friend has given, because how can a family member, as opposed to the sub-postmaster themselves, claim for compensation or for psychological help? Many of these families have broken up. Does my noble friend agree that the mere fact that there may be a lot of family members entitled to help or compensation should not of itself be a reason for denying them that help or compensation?
I thank noble friend and once again pay tribute to his continual scrutiny of this matter, and the fact that he has a vital role to play on the advisory committee. And where we are at the moment is that the compensation is directed to each claimant therefore being a postmaster or postmistress. But I would certainly say that the department, the whole point of having the advisory committee is to actually have live discussions on this, and I would encourage him in that capacity to keep those discussions going.
Last week I met several wronged sub-postmasters, most of whom were barely earning the minimum wage. They have been wronged by ministers, senior civil servants, lawyers, post office directors and investigators, and executives at Fujitsu. Can the Minister explain what legal advice and financial help the government has so far given or will give to the wronged sub-postmasters to enable them to bring the culprits to justice?
I thank the noble Lord for that question. As we've said before in the dispatch box, there is, as part of the compensation schemes, there is help available with the claimants to put their claim together, to get access to lawyers, to get access to health care. 78% of claims are settled. We are now dealing with the most difficult claims. In the meantime, there is a statutory inquiry going ahead which will get to the bottom of this, and we'll understand the full extent of how the sorry saga came about.
Lords, I'm sorry to hear Minister's answer. There is no help available for a mental health issue, but this is the fact on the ground, my Lords. I have spoken to quite a few Asian sub-postmasters, and they have all said they had some form of mental health issue either with them or with their families, and the reason they don't come out is because the way they were treated by the reason they don't come out is because mental health has a stigma attached to it, and this is why they said they're not talking about it. So can I humbly ask the government to look into this issue, especially amongst the Asian sub-postmasters who are not even wants to talk about it, and yet they do have a problem, and they admitted to me quite a few of them.
Noble Lord for that, and with his detailed knowledge of his own community, who serve us all so well, and who have suffered in some cases some terrible racism as well. And I think the point that we have to make is a communication issue. There's absolutely no stigma to this whatsoever. That the people who have been through this trauma undoubtedly have been harmed, and we must encourage everyone in our communities, wherever they are, to come forward with their claim.
Concludes all questions for today.
Digital Markets, Competition and Consumers Bill, order of consideration. Lord Offord of Garvel.
I beg to move the motion standing on the order paper in my name.
The question is that this motion be agreed to. As many as of that opinion will say content. Content. The contrary not content, the contents have it. Report of the Safety of Rwanda Asylum and Immigration Bill. Lord Sharp of Epsom.
My Lords, I beg to move that this report be now received.
The question is that this report be now received. As many as of that opinion will say content. The contrary not content, the contents have it. In Clause 1, Amendment 1, Baroness Chakrabarti, and we may just let noble lords time to leave before the noble lady stands up.
My Lords, after such a thorough committee, which showed this House, if not the government or its flagship policy in the best light, I'll be brief and urge others to do the same. This way, those seeking important votes will avoid self-harming delay and highlight any deliberate filibustering by others. My amendments in this group, shared with the noble Viscount Hailsham, the noble and learned Baroness Hale of Richmond, and the Right Reverend Prelate, the Bishop of St Edmundsbury and Ipswich, would add the purpose of compliance with the international and domestic rule of law to deterrence in Clause 1. They require actual evidence of real implementation of the Rwanda Treaty before that country is presumed safe, and that this only be presented by government to Parliament. That's all. I have revised my approach after the noble Lord Howard of Lympney's suggestion that initial decisions be in Parliament's accountable hands rather than those of others. While still finding the forced transportation of human cargo completely repugnant, I note my noble friend Lord Blunkett's distinction between offshoring and offloading by ensuring that those granted asylum be returned to the UK under the treaty. These are wholly reasonable amendments, but if the government still can't accept them, I will urge my noble friend Lord Coker to test the opinion of the House on his single requirement respecting the rule of law. Surely completely incontrovertible for those, like the Prime Minister, who now claim to be liberal patriots. That was 2 minutes, and I beg to move.
Amendment proposed. Clause 1, page 1, line 1, insert, after the, insert first.
To speak to this group. May I just begin by saying how much I regret the death of my noble friend Lord Cormac. He was a great friend of mine and a close colleague for over 40 years, both in the House of Commons and here. And he was also a very close Lincolnshire neighbour, and he rendered great service to the city and to the county. And of course, he was a very considerable parliamentarian, and he had, as I know this, intended to participate in these debates. And I think the contribution that he would have made would have been very significant. My Lords, he's a very great loss. My Lords, I hope that I will be forgiven if I remind your Lordships that for the reasons that I expressed at second reading and in committee, I am a root and branch opponent of this bill. In my view, many of its provisions are objectionable in principle. Moreover, I do not think that it will achieve the policy objective which it is intended to achieve, that is to say, to deter illegal migration across the Channel. However, I recognise that the government is determined to have this bill, so that I think our purpose at this stage should be to address some of its more objectionable characteristics. And it is in this spirit that I address the amendments in this group, and I adopt the approach of the noble Baroness Chakrabarty. My Lords, I can and I will support any of the substantive amendments included within this group that will be moved to a division. However, I would especially commend to your Lordships Amendment 3, which is in the name of the noble Baroness Chakrabarty, and which I have signed. One of the great deficiencies in this bill is that it purports to describe Rwanda as presently a safe country, when both the Supreme Court and this House have decided otherwise. Now, the government relies on the treaty as being sufficient evidence of present safety. In my view, that is clearly not a sustainable position. It is possible that Rwanda will become a safe country, and that is when the treaty is ratified, when its provisions have been implemented, when the infrastructure is in place and working, and also if the culture of the country has changed. All of that may happen in the future. It has not happened yet, and on any view, it will require assessment. And clauses 1B and 1C in Group 3 of the Noble Baroness Amendment is designed to provide a mechanism for such an assessment. The amendments provide that the initiative lies with the Secretary of State, and that takes account of the observations made by my noble friend Lord Howard of Nymphs at second reading, when he stressed the importance of proper democratic accountability. The amendment ensures just that, and I commend Amendment 3 to the House. However, if others in this group are the subject of division, I shall support them.
My Lords, I would like to speak to Amendments 10 and 43 in my name included in this group. My Lords, I remain concerned about the potential constitutional fallout from this bill, despite what my noble friend Lord Hannay has referred to as a sterile issue. There must be a reference to its remarkable impact on vital constitutional elements, such as the rule of law, the separation of powers, and parliamentary sovereignty. Although these are probing amendments, such as the gravity of these possible consequences, they surely deserve to be noted, if not on the face of the bill, at least in the record of its passage. The Supreme Court has stated unequivocally in a former judgment, and I quote, "The courts will treat with particular suspicion any attempt to subvert the rule of law by removing governmental action affecting the rights of the individual from all judicial scrutiny." In this bill, the government is doing just this by writing into law a demonstrably false statement that Rwanda is a safe country to receive asylum seekers, and thereby forcing all courts to treat Rwanda as a safe country despite clear findings of fact. It's clear, my lords, that the bill subverts the rule of law, the key elements of which are abiding by international law, equality before the law, respect for fundamental human rights, and guaranteeing access to the courts. These rights are negated by this bill, and as such, it is a legal fiction. The longer-term impacts might be considerable. For example, could the Supreme Court in future rule with any authority a prorogation unlawful? The bill in its present form enjoins all relevant courts and officials to deem Rwanda a safe country, and it specifically disallows any rational challenge by the courts. The noble Lord Clarke of Nottingham at committee stage expressed the hope that there will be a challenge thereby enabling the Supreme Court to strike the bill down as unconstitutional. Should this happen, a review of the impact of the bill on the rule of law in the UK would prove invaluable evidence.
In favour of Amendments 1, 3 and 5, tabled in the name of the Noble Baroness Chakrabarti, to which I have added my name. I do not believe that we can enshrine in law a statement of fact without seeing and understanding the evidence that shows such a statement to be true, in particular when such a statement of fact is so contentious and for which the evidence may change. Ignoring for a second the strange absurdity of such declarations, we must also consider the real impact that this could have on the potentially vulnerable people whom the government intends to send to Rwanda. As my most reverend friend, the Archbishop of Canterbury, in his place, said at the second reading, the dignity of the individual is at the heart of what is believed by almost every tradition of global faith and humanism around the world. Sending those who seek refuge in the UK to a country of questionable safety does not respect this dignity. So I support amendments that require further evidence of the safety of Rwanda before anyone is sent there.
Support all the amendments in this group, and it is absolutely critical that domestic and international law is complied with, and this should not be up for debate. It's who we are. It's what we stand for. And if we seek to deviate from our domestic and international legal obligations, our role on the world stage and our ability to have influence globally is significantly diminished. We cannot shy away from the consequential impact this will have on other countries choosing to follow suit. As the United Nations Council for Human Rights put it last Friday, international standards on the independence of the judiciary are closely linked to the rule of law and the separation of powers. Provisions of the Rwanda Bill could undermine the principles of the separation of powers and the rule of law in the United Kingdom. That is sufficient for us to support all of these amendments.
My Lords, I begin by associating myself with the remarks of my noble friend Viscount Helsham about the late Lord Cormac. I can't add anything to what my noble friend said, but it is entirely true that he is a great loss, and we shall all miss him tremendously. I'm grateful to the noble Baroness, Lady Chakrabarti, and to my noble friend for their references to my earlier intervention in these debates. I'm not sure that the further interpretation which they placed on my intervention is entirely justified, or that I would entirely go along with it, but I think that is perhaps a matter for debate at a later stage. These amendments, the amendments in this group, are all based on a respect for the rule of law. And a critical part of respect for the rule of law, something much referred to in our earlier debates, is the separation of powers. And it is to that subject that I propose to address these remarks. As Anthony Spate, KC, reminds us in his recent Politeia pamphlet, there is no such thing as the absolute separation of legislature, executive, and judicial powers in our constitutional arrangements. Our executive is rooted in our legislature, and in any event, as Mr. Spate and others have pointed out, there are precedents for this legislation, including the Asylum and Immigration Treatment of Claimants Act of 2004, passed under the Blair government. Precedents for the proposition that Parliament can deem certain countries to be safe. That principle, the principle in that legislation, was challenged in the case of Nasseri, but upheld by the Court of Appeal and the House of Lords. And that, of course, is essentially what this bill does. It deems Rwanda to be a safe country. But there is an even broader principle that is relevant here and is at the root of why this legislation is necessary. We have traditionally recognised the separation of powers between the executive and the judiciary. That principle can be expressed in the proposition that decision-making is the responsibility of the executive, but that the courts have the responsibility to review the lawfulness of those decisions. That responsibility of the courts is what we know as judicial review. Its scope has been expanded greatly in recent years in ways which have not found universal approval, but its principle is accepted as an important part of our constitutional arrangements. But judicial review does not involve the courts substituting their own decisions for those of the executive. It involves, in essence, an assessment of whether it was reasonable for the executive to make the decision in question. That was the approach the divisional court took in the case which gave rise to this bill. The divisional court held that the government's decision was lawful, and I imagine that if things had rested there, the government would not have asked Parliament to consider this bill. But as we know, things did not rest there. The Court of Appeal, by a majority, and the Supreme Court held that the divisional court had applied the wrong test. The correct test, said the Supreme Court, at paragraph 34 of its judgment, requires the court to decide the issue for itself, to substitute its own decision for that of the executive. And that is exactly what the Supreme Court did. It took that approach, it said, at paragraph 34 of its judgment, because it was following a decision of the European Court of Human Rights in a case called Surin. But as the Supreme Court itself recognised at paragraph 28 of its judgment, the Human Rights Act requires it to take into account decisions of the European Court. As is now well established, it does not require it to follow them. So I suggest to your lordships that in resolving to decide this issue for itself, the Supreme Court was trespassing on the province of the executive. And if there is any breach of the principle of separation of powers in this matter, it is not the government which is guilty, it is the Supreme Court. All the government is doing in this bill is to reassert its responsibility as traditionally understood by the principle of the separation of powers for executive decision-making. And there is a reason why it is the government and not the courts which has that responsibility. It is because it is the government and not the courts which is accountable. The courts are accountable to no one. They pride themselves on that. But accountability is at the heart of democracy. That is why, my lords, the government is fully entitled to bring forward this bill, and why much of the criticism which is directed at it for doing so is, for the reasons I have given, fundamentally misconceived. That is why I oppose these amendments.
My Lords, that's a very interesting speech, but actually what we're being asked to do here is to actually vote on an opinion. And I think the noble Lord knows that most of us don't actually agree with that opinion. I'm only going to speak once in the bill today. I am deeply offended it's ever been brought to us. I think it's a mess of a bill, and it's illegal and it's nonsensical, and we, your Lordship's House, is being asked to actually indulge in pointless chatter for the whole day and for another day, and it's pointless chatter because whatever we say, the government will not listen to us. And this is partly fuelled by the Labour front bench, who seems to be rewriting the Salisbury Convention. The Salisbury Convention being that we do not try to stop anything in the government's manifesto. But in fact, what the Labour front bench is now saying, they are suggesting that, and they've said it several times, it's been articulated on numerous occasions, is that the Lords must not interfere with any legislation or decision by the government or the Commons because they are elected and we are not. Then what is the point of your Lordship's House? The point is we have centuries, possibly millennia, of experience and knowledge, and we did have the opportunity to stop this foolish bill. And the Labour front bench decided we would not. They whipped to abstain. I think that's an abnegation of their responsibility, and I'm absolutely horrified by that. And it grieves me that they might actually win the election and then behave in the same way. I think they're hoping that the current government is going to actually respond in kind and not block any bills, and I think that's a false hope. So we Greens will vote for any amendments that come up today, but quite honestly, we are wasting our time.
My Lords, I shall be extremely brief. Some important points have been made, but I'd just like to focus on the exact drafting of Amendment 3, which is clearly essential and clearly what the vote will be about. The puzzling aspect is that in new paragraph 1b makes the condition that the Secretary of State should consider all the relevant evidence and be satisfied that Rwanda is a safe country for the processing of asylum and humanitarian protection claims. Fine, no problem. But then it goes on to say this. It continues, before successful claimants are returned to the UK by request of the Secretary of State under Article 11.1 of the Rwanda Treaty. Well, I've looked at Article 11.1 and it doesn't say that. What it says is that the UK may request the return of a relocated individual, may request. And the explanatory notes to the bill in paragraph 12c describe this as a response to the Supreme Court judgment by, quote, creating a mechanism for the UK to require the return of a relocated individual. My Lords, which is it? Is this providing for the Secretary of State to bring people back? Or is it, as the noble Baroness implied, actually that will be the outcome, that is the purpose of the whole thing? I think that's the case, but the language needs to be cleaned up, if it's, or perhaps the noble Baroness would confirm it, so that we know what we're voting for.
My Lord. I would like to begin by paying my tribute to my old friend Lord Clarke, who I've known for 60 years. I first met him when I was fighting the then ultra-safe seat of Mansfield, and he was fighting the ultra-safe Labour seat of Bassetlaw next door to me in the 1964 election. And since that time, he's been a very good personal friend of mine for well over 50 years in Parliament, when we both got there in rather better bases for our political careers. He was an extremely good man. I think he was always regarded as speaking too much in the House of Commons and in the House of Lords. That has to be admitted. He was always forthright in his views. But I think that rather ignored the fact that overwhelmingly he spoke very sensibly, extremely well, and the principles which guided him throughout his political career were extremely sound principles, and we will all miss him. I won't repeat the arguments I've made. I just acknowledge that my noble friend Lord Hailsham has made a speech with every word of which I agreed with. And I do think the government is in an impossible position. Again, another good personal friend, my noble friend Lord Howard, made, I thought, a brilliant attempt to defend the position and to try to demonstrate that the bill is compatible with the things he holds as dear as I do, the rule of law and the separation of powers, but I fear that he fails. His arguments might apply if we were talking here about a matter of judgment, political judgment, on a given set of facts which the government is making a policy decision about. But this bill is solely about asserting a fact to be a fact, regardless of any evidence, and regardless of the fact that the Supreme Court judges, 5 of them, unanimously considered that evidence and came to the conclusion, which isn't too surprising, that Rwanda is not a safe country. And this bill, I cannot recall a precedent in my time where a government of any complexion has produced a bill which asserts fact, a matter of fact, facts to be fact, and then goes on to say that this should be regarded legally as a fact interminably until and unless the bill is changed, and then goes on to say that no court should even consider any question of the facts being otherwise. It's no good blaming the Human Rights Act. I do not believe that it was in any way probable that the British courts were going to come to any other conclusion. And if the Labour Party allow this bill to go through, I very much hope there'll be a legal challenge, and the Supreme Court will consider it, obviously, objectively again, and consider it again, but I think it's likely they are likely to strike it down again as incompatible with the constitutional arrangements which we prize so much in this country. So I, too, will be supporting any of the amendments in this group which are introduced. I think it's a very, very important principle that we're seeking to restore.
Brief, but I'd like to associate myself, first of all, with the remarks of the noble Lord Clarke of Nottingham, the noble Lord Howard of Lympney, and the noble Viscount Hailsham, concerning Patrick Cormack, who was a dear friend of many of us. He was kindness itself to me when I became a member of another place in 1979, and there were many issues on which we worked with one another, not least on issues around Northern Ireland, and he did great service, I think, in uniting people around a complex and very difficult question during the years that really mattered. We were in touch with one another in writing just 2 weeks before his death. He had gone back to Lincoln in order to care for his wife, Mary, and he was deeply troubled about how ill she was, but he hoped soon to be back in his place. My lords, we will all miss him not being in his place and contributing to your lordship's house. My lords, I have just 2 questions I'd like to put to the noble lord, Lord Sharp of Epsom, who will reply on behalf of the government, or to his noble and learned friend, Lord Stewart. I'd like to ask about the question I put during committee stage concerning the report of the Joint Committee on Human Rights on which I serve. And then I did ask the noble Lord Sharp at that stage whether before we considered this bill at report stage we'd have a proper reply from the government to that Select Committee report. I think it's deeply troubling that there has been no reply, and I think it's deeply troubling that Select Committee is not least one like a joint committee of both houses can give a view about this bill specifically around the question of safety, and in a majority report say that it does not believe it right to say that Rwanda is a safe place to repatriate refugees to, and not to have a response to those findings before your lordships are asked to vote on amendments at the report stage of this bill. So that's my first question. The second question also concerns safety, the safety of our reputation as well. I was troubled to read reports over the weekend that £1.8 million will be spent for each and every asylum seeker for the first 300 who are going to be deported. That was described by the chair of the Home Affairs Select Committee in another place as a staggering figure. The Home Office declined to give information about it because of what they said was commercial confidentiality. I cannot believe, my lords, that such a lame reply would be given, and indeed I don't expect the noble lords who come to reply today to use that excuse. I don't think it is right for Parliament to be asked to take awesome decisions that will affect the lives of ordinary people, and to do so without giving all the facts to Parliament first. I'll end by simply saying I've been reading the magnificent book East-West Street by Philip Sands, KC. And when you consider the way in which this country responded at that time to people like Philip Sands' family who had fled from Lviv in what is now Ukraine, when you consider the generosity of spirit and the response from people in both Houses of Parliament, from all political traditions, it seems to me to contrast, sadly, dismally, with the way in which we are responding at this time through this bill. My Lords, I hope the noble Lords will be able to reply to my questions.
My Lords, I've listened to and read the debates so far with great respect. They've been dominated by distinguished noble lords who are lawyers, and I am not. I just want to raise two questions of fact and why ask those noble lawyers, and indeed the distinguished prelates, why they haven't mentioned them up to now. The first has only just been mentioned by my noble friend, the Lord Howard, who mentioned, contrary to what has been asserted many, many times, that Parliament cannot, by law, state whether or not a country is in fact safe, that in 2004 the Blair government did just that and introduced legislation which created an irrebuttable presumption that a number of listed countries were safe. It was subsequently chested in the courts and upheld. Why have none of the noble lords who've asserted we can't do that mentioned and dealt with the fact that we have done that in the past? The second factual thing is a point raised by the noble lord who spoke from the Lib Dem benches, saying that if we do this sort of thing, if we give ourselves, or the sort of thing in the bill that gives us the right to override international law and not necessarily to respond to decisions and demands of the European Court, we would forfeit our respect and ability to influence people in the international arena. And I want to ask him and others who've made a similar point why they don't mention the fact that the French government has done just that, has returned an asylum seeker to Uzbekistan despite the order of the European Court that they should not do so, and despite even a ruling of their own Conseil d'État that they should bring him back. Have they lost all respect in international fora? Have they lost any ability to influence public opinion internationally? And why do they not get mentioned in this place?
Would my noble friend give way?
Of course.
I can't claim to remember clearly, but did anybody challenge with any evidence the earlier cases that he tries to quote as a precedent? And if anybody had had evidence showing facts to be contrary to what was then laid down in statute, does he think it would have survived a challenge in today's Supreme Court?
Well, I can't say what today's Supreme Court would do, but the Supreme Courts of our country in those days did entertain a challenge that Greece in particular was not thought to be safe, and presumably they wouldn't think now France is safe. And they upheld the right of the executive to make those decisions and didn't try to supersede them with their own or consider evidence as to whether or not those accusations were correct.
But would my noble friend give way? This is a different situation because here we have the expression of opinion by the Supreme Court. That is being displaced by the government through legislation.
Look, can I just say, I don't think it's relevant to quote France. The fact is this country has a great reputation for upholding the rule of law and international law, and we play a great part across the world. This bill is threatening that reputation and that role. France doesn't have that reputation or role, in my opinion.
I'm not sure what the noble Baroness's question to me is, but as a great Francophile, I'm sorry to hear her abuse of the French nation in that way. My noble friend said this is different because the Supreme Court has expressed an opinion. This amendment, Amendment 5, says that we should, that a purpose of the bill should be to uphold the rule of law. As I understand it, the rule of law in this country for 1,000 years has meant that laws made and approved by our elected representatives are impartially implemented by the courts, and all of us, citizens, public officials, ministers, police, even lawyers and bishops, are subject to those laws. But if we don't like the law, we can try to persuade our elected representatives to change it. And if Parliament feels that the courts have interpreted laws in the way that Parliament did not intend, or it feels is out of line with the values and interests of the public who elect it, Parliament can change the law. That is what we are doing, and we have a perfect right to do so as long as Parliament remains sovereign. I give way to the sorry, he's not intervening.
My Lords, I rise because, as a member of the Joint Committee on Human Rights, last Thursday I was in Rwanda. More particularly, I was in the Rwandan Parliament. And I can confirm to your Lordship's House that on Wednesday of last week, the Rwandan Chamber of Deputies ratified the treaty by 64 votes to 2. Rwanda is a monist country, unlike this country, which is a dualist country. That means that the international obligations of Rwanda are enforceable in domestic courts. Once ratified by the Senate of Rwanda, the treaty will have effect legally within Rwanda. Noble Lords will recall that the basis upon which the Supreme Court found Rwanda to be unsafe were particularly set out in the judgment. The treaty obtained by the United Kingdom government with the government of Rwanda was each and every paragraph targeted at the decision of the Supreme Court. Noble Lords will notice that with the approval and ratification of the treaty in Rwanda, there is simply no basis upon which it can be said Rwanda is unsafe. These amendments are unnecessary.
Put a question to him. If that is so, why is it, or how is it, that a number of refugees from Rwanda have been given asylum protection in this country?
As the Noble Lord will be well aware, the treaty is directly reflective of all the Supreme Court's concerns as to the safety of Rwanda. The fact that there are refugees from a certain country does not mean that that country is of itself always and everywhere unsafe.
My Lords, it seems to me that at this stage of the debate on this group, we're looking at two distinct things. One is the question of whether Rwanda is safe, and if indeed, as the Noble Lord just said, it is unquestionably safe, then it seems to me that these amendments are not a problem, because at that point the Secretary of State can easily say it's safe, and they will have evidence for that in this and future governments. But the object of this group is around the rule of law, and that is the main subject we're looking at. And there is a difficulty if we go back to the development of international human rights law, particularly in the period after 1945, in totally separating domestic and international law. The rise in international human rights law grew out of the horrors of the 1940s, where a government that in 1933 in Germany had been legally and properly elected passed horrific laws that did terrible things, starting from within a few weeks of the election of Adolf Hitler. That continued, and most historians agree that the first two elections gave the Nazi Party a legitimate majority. Winston Churchill's advocacy of the European Court of Human Rights after the Second World War grew up in order to give a fallback where domestic law was not
doing the right thing by linking it to international law and ensuring that there was a stop that said, well, you can do this perfectly legitimately domestically, but that doesn't mean it's always right and always the right thing to do. Now, we're not in any situation remotely like that. Let's be clear. The government is not doing something on the scale of what we saw at that stage. But the government is challenging the right of international law to constrain our actions. And the point of international law is to stop governments going ahead with things that are wrong. Noble Lord Lilly made a very good point, two very good points, particularly in his questions. But one of the things I was brought up on believing, and even, believe it or not, when I was trained as a clergyman, and we do get trained, though it may sound surprising from time to time, one of the things we were told is there's a basic rule of ethics and morality that two wrongs don't make a right. So the fact that we've done the wrong thing in the past doesn't automatically make it right today.
It's a privilege to follow the Right Reverend Prelate, and I should like to begin by saying how much I agree with every word that my noble friend Lord Clarke and my noble friend Lord Hailsham said about my old friend Patrick Cormack. He was a good man, he will be very much missed, and I cannot add to what they said, but I do so humbly and with great warmth. Now, at this stage of the proceedings, our task is to try to persuade the House of Commons to improve this bill, and failing that, it is to draw attention to the implications of leaving the bill as it is. And I support this amendment and others which will follow, because I believe that the failure to amend this bill will have profound implications. The government will in fact be behaving like the ruling party in George Orwell's 1984. Now, normally, 1984 is invoked in relation to government behaviour, laws, events, and so forth in tyrannies and dictatorships. And this country is no dictatorship, it is a democracy. Nevertheless, in this bill, it is seeking to achieve by Act of Parliament what in 1984 the ruling party and its apparatchiks sought to achieve by torture. Many noble lords will remember the scene towards the end of the book in which Winston is being interrogated by O'Brien. He is forced to say that Oceania is and always has been at war with East Asia, although he knows for a fact that until recently it had always been at war with East Asia, though he knows for a fact that it was until recently at war with Eurasia. When O'Brien holds up 4 fingers, he is obliged to say that he sees 5 as an act of obedience to the party. However many fingers O'Brien holds up, the answer is always the same, just as, whatever the evidence to the contrary, Oceania has always been at war with East Asia. Likewise with this bill as it stands. It doesn't matter what the Supreme Court has said about the present or how conditions in Rwanda might evolve in the future. The answer is always the same. Rwanda is a safe country. If this bill goes onto the statute book in its present form, Rwanda will be a safe country regardless of reality until the statute is repealed. Now, rather than going down that route, we should, I think, take our cue from what Margaret Thatcher told the House of Commons on the 17th of July, 1984, as it happens, when a judge had held that a decision her government had taken in connection with GCHQ was illegal. I rightly cannot overturn the decision of a court, and I would not wish to do so, she said. And then she went on, at the end of the judicial process, governments, of course, accept the court's final ruling. That is what the rule of law is all about.
too was in Rwanda last week. And I think what Lord Murray seems to have left out is our last meeting that we had with the UN HCHR, where they talked about the international rule of law. And what they said about Rwanda is not safe. There's certain process that Rwanda needs to put in place before it can be seen as a safe place. So my Lord only gave you one part of what was said. Everywhere that we were, everybody said that Rwanda was safe. But Rwanda's got so many refugees there already in different camps. They're not facilitated within the country at the moment. They're in camps. So what the UK is doing, they're building a vast area of accommodation. And my question to a lot of people was, what is the impact of when we send over 300,000 people over to Rwanda? What's the impact on the local community? And nobody can answer that at the moment. So there's still a lot of work to do for the Rwanda government, for the UNCHR to say it is a safe place. Until that happens, it is not safe.
Lords, two brief points, if I may. Firstly, Patrick Cormack. Yes, he did speak often, and yes, that was sometimes frustrating. But what was doubly frustrating was that he was brilliant at synthesizing views across the House and lobbing them forward to his front bench with quite difficult questions, something I learnt to appreciate over time. Secondly, Lord Clarke's speech to us just now, I think all of which I agreed with, he was searching for an international precedent, as have others, for this bill. And I would simply direct him to one also from Central Africa, where the president of the country at that time declared by legal presidential decree that there was no AIDS in his country. It made him an international laughingstock, and I can't help thinking this bill feels rather the same.
My Lords, first of all, it's a pleasure to wind up for His Majesty's opposition this group of amendments, and having listened to the quality of the debate we've become used to as we've debated the Rwanda Bill. But can I start by associating myself with all the remarks that have been made about Lord Cormack, and to add my recognition of the marvellous individual that he was. And in marking his passing, can I also mark the passing of my noble friend Baroness Hennig in recent days. Again, I'm sure more fuller tributes will be made about her, but again, a loss of a valued colleague. Can I also start by saying, in moving my own amendment 2 to Baroness Jones and the challenge that she presented to me, let me just say this: if we were to win the next election, the big advantage we would have is we would be in power and we'd repeal the bill. And that's the point I would make to the noble Baroness. And also just to say, it is our view, whether it's universally held by every single person, it's certainly our view that it's important for us to respect what we see as the traditions, the constitutional traditions of the House. We would expect them to be followed were we to be in power, and that's why we take the position that we do. But I would say to the government, which is what I've said on a number of occasions, the Constitutional Convention also requires the government to listen to what the House of Lords says, to respect what the House of Lords says, and to listen, not just dismiss them before they've even been discussed. And that's the point that we've continually made throughout this debate. The government may disagree with all of the amendments, but to dismiss them, as the government has done, before this House has even debated many of the amendments, I would say that that is undermining the constitutional proprieties of the way this country operates. And as much as the government says to us we should respect those, so should the government with respect to them considering the amendments that your lordships consider and indeed on occasion passes. My Lord, can I thank my noble friend Baroness Chakrabarty for her amendments and for the way that she put them. She will see that I've put my own amendment to which seeks to say that the bill should comply, or the Act as it will be, should comply with domestic and international law. I want to focus particularly on the international law aspects of it, but I would refer, noble Lords, with respect to the debate that we've had around domestic law, is the report of the Select Committee on the Constitution, which made a number of challenges to the government about how it was that the government simply by legislation saying something was a fact, how that accorded with the separation of powers. Indeed, in clause 11 of that report, it says clause 1.2b, which says this act gives effect to the judgment of a parliament that the Republic of Rwanda is a safe country. The Select Committee says clause 1.2b could be interpreted as a breach of the separation of powers between Parliament and the courts. It is the role of Parliament to enact legislation. It is the role of the courts to apply legislation to the facts. And what this bill has done is by legislation saying the facts are not convenient, so we'll change them by legislation, simply to say that Rwanda is safe by an act of law rather than by application of that legislation to the facts as they are within the country. But in moving from domestic law to international law, I think it is of extreme importance. Viscount Hailsham, very helpfully at committee, pointed out the quite astonishing part of the bill, clause 3, in clause 1, 3.4, where it says it is recognised that this act, the validity of an act, is unaffected by international law. I think that's quite an astonishing, and then goes on further in the bill to actually then list all of the various laws and conventions to which the Act doesn't apply. And I just think, as a country, is that really where we would want our legislation to be? To say the United Nations Convention, my noble friend Baroness Lawrence referred to the UN Commission and their view of the bill, which they say is incompatible. Are we saying that is simply doesn't matter, just dismiss that with a wave of the hand? We'll pass legislation to say it doesn't matter. The fact the Council of Europe is disapplied from this legislation, no, it doesn't matter. What's the Council of Europe? The fact that it was mainly large numbers of Conservative politicians, not least Churchill, but also Maxwell Fyfe and others, who actually moved forward that legislation, just dismiss it with a roll of the hand. It doesn't matter. All sorts of other conventions just dismissed with a wave of the hand as though it doesn't matter. And yet, time after time from the dispatch box in here, not only in this place but in the other place, we have the respect for international law used as a justification for the actions this country takes. Whether it be in the Red Sea with respect to the Houthis, where the international law of the sea is actually used as a justification, quite rightly, for the action that we take. When we demand of Russia that they don't have the illegal invasion of the Ukraine because it breaks international law, we appeal to international law with respect to that. When we talk about foreign courts, often used as a disparaging term to actually refer really to international courts which we've actually agreed to become a part of. Where is it that we wish to take Putin as a result of what he's done with respect to the Ukraine? To an international court, actually held to account by international law. All of these examples of where we would expect international law to apply to the actions of a particular individual or a particular government. And the purpose of the amendment I've put, yes, with respect to domestic law, but with respect to international law, is to say that it matters what this country does, because we often stand in all of the international institutions of which we are a member, to say that international law is important, that international law should be applied, that international law should be adhered to. And we do that because we recognise that if that isn't done, that is the road to chaos. That is the road to confusion. That is the road to problems across our world, not getting better, but getting worse. And therefore, it is of particular importance that we actually ensure that this Act, which is dealing with a difficult problem that we all wish to see solved, it's not between those who would wish to see it solved and between those who don't. There is difference between how we would wish to do that. But I would say to this chamber that what we would wish to do is to see the challenge of the small boats and the challenge that we see in our country with respect to immigration, migration, refugees, asylum seekers, that there is a need for that to be dealt with. But let's do it in a way which is consistent with this country's proud tradition of the respect for law, both our own domestic law, the separation of powers, but also with respect to the international laws based on treaties we signed as a free, independent country. And with that, I move my amendment 2.
My Lords, in rising from the government front bench to respond, may I first of all speak on behalf of the government front bench in relation to noble lords who have recently passed out from this chamber and out of this life. My Lords, I echo everything that was said about the noble lord, my noble friend Lord Cormac, and I didn't know as well the noble Lord Lord Coker's colleague Baroness Hannay as he did, but I mourn her loss. Although I can't speak for her, those better able to speak about her, those better able to speak about her will in due course speak. My Lords, as to Lord Cormac, I can say something. If the welcome which he extended to the noble Lord Lord Alton of Liverpool on his entering to the other place was as kind, as heartening, as pleasant, and as wise as the one which he extended to me on my coming amongst your lordships a scant few years ago, I would be very surprised. My Lords, the House, I think, will miss his contribution to our deliberations. My Lords, as the noble Baroness Lady Chakrabarti set out, Amendments 1, 3 and 5 add the purpose of compliance with the rule of law to that of deterrence in Clause 1, requiring the Secretary of State to consider all relevant evidence and lay a statement before Parliament that Rwanda is currently a safe country. Amendment 10, tabled by the noble Lady Baroness de Souza, would mean that decision makers cannot conclusively treat Rwanda as safe if the Supreme Court rules otherwise, even if Parliament had declared that it is safe. My Lords, the overarching purpose of this bill is to deter dangerous and illegal journeys to the United Kingdom, which are putting people's lives at risk, and to disrupt the business model of people smugglers who are exploiting vulnerable people. Now, my Lords, in relation, picking up a point which my noble friend Viscount Hilsham made in speaking earlier on in the debate, my Lords, we know that deterrence can work. We have seen through our Albania partnership where we have removed over 5,700 people, and the number of small boat arrivals has dropped by 93%. The number of migrants crossing the Channel has fallen year on year for the first time since current records began, with the total arrivals in 2023 down more than a third on 2022. And, my Lords, we know that this is not a Europe-wide trend. There has been a 16% increase in detected irregular arrivals to Europe. My Lords, it is through this government's joint work with France which prevented over 26,000 individual crossings by small boat to the United Kingdom in 2023. Since July 2020, the Joint Intelligence Cell and French law enforcement partners have dismantled 82 organised criminal gangs responsible for people smuggling of migrants via small boat crossings. But as we know, my Lords, the small boats problem is part of a larger, a global migration crisis, and one that this government is committed to tackling, along with its international partners. The MEDP, the Migration Economic Development Partnership with the Government of Rwanda, is one part, my Lords, of our wider programme to stop the boats. This partnership will not only act as a strong deterrent, but also demonstrate that it is not necessary to take dangerous and unnecessary journeys to find safety, as promoted by the smugglers. And this partnership with the Government of Rwanda has now been set out in a new treaty binding in international law. As your Lordship's House heard from my noble friend Lord Murray of Blidworth a moment ago, ratified by the lower house of the Rwandan Parliament and moving on to its upper house. This treaty has been agreed by the governments of the United Kingdom and Rwanda and was worked on by both parties with close care and attention. As has been set out repeatedly in earlier debates, the government respects the decision of the Supreme Court in the case of AAA against the Secretary of State for the Home Department. I would, however, remind noble lords that the Supreme Court's conclusions were based on evidence submitted prior to the High Court's hearing in September 2022 and did not consider the subsequent ongoing work that has been undertaken between the United Kingdom and the Government of Rwanda since the partnership was announced to prepare for the operationalisation of the partnership and later to address the findings of the Court of Appeal. Indeed, my Lords, the Supreme Court recognised that changes may be delivered in future which could not address the conclusions they reached. And as I've just set out, my Lords, we have done this through the treaty. So, again, my Lords, I repeat, the bill and the treaty do not overturn or disregard the Supreme Court's decision, they act upon it. My Lords, the treaty, at Article 10, ensures that people relocated to Rwanda are not at risk of being returned to a country where their life or freedom would be threatened. It ensures that people relocated to Rwanda who are not granted asylum will receive the same treatment as those recognised as refugees, including permanent residents. It strengthens the Rwandans' appeal system, including through the constitution of a new appeal body composed of judges from Rwanda and from other countries with asylum and humanitarian protection expertise to hear individual appeals. It clarifies the availability of free legal representation for all stages of the process and availability of free legal representation for court appeals, and enhances the functions of the Independent Monitoring Committee. The United Kingdom and Rwanda have been working together to improve systems and to develop the partnership. That work and the assurances we have negotiated in our legally binding treaty with Rwanda address the findings of the Supreme Court and make detailed provision for the treatment of relocated individuals in Rwanda, ensuring they will be offered safety and protection with no risk of refoulement. The implementation of these provisions in practice will be kept under review by the Independent Monitoring Committee, whose role, as I just set out, was enhanced by the treaty and who will ensure that the obligations under the treaty are complied with in practice. The amendments tabled by the Noble Lady Baroness Chakrabarti and the Noble Lady Baroness de Souza are therefore not necessary. Though, as the Noble Lady Baroness Chakrabarti has set out, the amendments in the Noble Baroness's name do take into consideration the views expressed by Noble Lords during these debates. These amendments would in fact delay the operationalisation of this partnership. This treaty, I repeat, does not override the judgment, and it is precisely to address the concerns of the Supreme Court that the government has concluded this international treaty with the Republic of Rwanda with additional safeguards and guarantees, as well as publishing an evidence pack on what has changed. The changes, along with a wider evidence pack, address the findings of the Supreme Court. Furthermore, my Lords, Amendment 3 appears, and I follow here the reasoning of the Noble Lord Green of Deddington in his contribution earlier. Amendment 3 appears to be intended to require persons whose claims are successful in Rwanda to be returned to the United Kingdom. Now that, my Lord, goes against the spirit and intention of the treaty. Those relocated to Rwanda are not going to be returned to the United Kingdom except in limited circumstances. They will be given safety and support in Rwanda. As previously set out, it is our view that Parliament and the Government are better suited to addressing the sensitive policy issues involved in this legislation and the matters with which it deals, and ultimately tackling the major global challenge which we face of illegal migration. The Government's published legal position makes clear that Parliament is able, with clear and express words, to limit access to the domestic courts. And while previous attempts have not always prevailed, Parliament has done that in the recent past in ways which have been upheld in the courts. These recent successes have been clauses which, while they ousted most claims, did not oust all claims. As a recent judgment in the case of L.A. Albania in the Upper Tribunal made clear, against the Upper Tribunal, the fact that an ouster provision was not a total provision, was not a total ouster, was an important consideration for the court to give effect to that ouster. The court decided that the ouster did not offend the rule of law and gave effect to it. The bill does allow Parliament to confirm that it considers it has sufficient material before it to judge that Rwanda is in general safe and that this finding should not be disturbed by the courts. The bill also allows for an exceptionally narrow route to individual challenge to ensure that the courts will interpret the relevant provisions in accordance with the will of Parliament, recognising that it is not, however, possible for Parliament reasonably to conclude that Rwanda will always be safe for every potential individual liable to removal at any point in the future, irrespective of their specific personal circumstances. My Lords, completely blocking any court challenges would be a breach of international law, and alien to the United Kingdom's constitutional traditions of liberty and justice. The bill limits unnecessary challenges whilst maintaining the principle of access to the courts where an individual may be at real risk of serious and irreversible harm. Taken as a whole, the limited availability of domestic remedies maintains the constitutional balance between Parliament's being able to legislate as it sees necessary and the powers of our courts to hold the government to account. My Lords, with regards to those amendments 1, 3, 5, 10 and 43 put forward by the noble Baroness Lady Chakrabarti and...
Would my noble friend give way?
Yes, of course.
His assertion is that the government is actually complying with the rule of law and respects positions of the courts and so on. Why is it that the bill expressly rules out any court in future considering any evidence that Rwanda perhaps is not complying with the treaty he's described? And why does the bill expressly rule out the provision of various features of international law when it comes to consider future behaviour by the government of Rwanda? The terms of the bill seem to contradict the complete confidence with which my noble friend is putting forward this ideal situation that's likely to prevail for all time on the ground in East Africa.
The point of the bill is to move the matter into the diplomatic and political sphere. And the bill and the treaty make the point that the matters are better considered there than they are in the court. That is my answer to the point which my noble friend takes. My Lords, I also refer to the Amendment 2 put forward by the noble Lord Clarke. I cannot accept that the provisions in this bill undermine the rule of law. Amendment 2, that this legislation is not compliant with the rule of law, is simply not right. My Lords, the bill is predicated on both Rwanda's and the United Kingdom's compliance with international law in the form of the treaty, which itself reflects the international legal obligations of the United Kingdom and Rwanda, as again my noble friend Lord Murray of Blidworth pointed out following upon his recent visit. As has been stated in the debates on this bill, the government takes its international obligations, including under the European Convention of Human Rights, very seriously. And there is nothing in this bill that requires any act or omission that conflicts with the United Kingdom's international obligations. Along with other countries with similar constitutional arrangements to the United Kingdom, and again echoing points made by my noble friend Lord Murray of Blidworth, we have a dualist approach where international law is treated as separate to domestic law and international law is incorporated into domestic law by Parliament through legislation. My Lords, this bill invites Parliament to agree with its assessment that the Supreme Court's concerns have indeed been properly addressed, and to enact the measures in this bill accordingly. This bill reflects the fact, going back to my noble friend Lord Howard of Lympney's opening points, reflects that Parliament is sovereign and can change domestic law as it sees fit, including, if it be Parliament's judgment, requiring a state of affairs or facts to be recognised. My Lords, the principle of recognising that certain countries are safe for immigration purposes, as your Lordships heard from my noble friend Lord Lilly in his submission, is a long-standing one, and one that is shared also by many other countries as part of their respective systems. It is also the case that the European Union states are not the only countries that may be safe for these purposes. So, my Lords, to act as the government is proposing to act in terms of the bill, is not an unusual thing would not be an unusual thing for Parliament to do. There is other immigration legislation which Parliament recognises that states are generally safe. It is not akin to Parliament stating something to be the case contrary to the actual position. The bill reflects the strength of the government of Rwanda's protections and commitments given in the treatment to people transferred to Rwanda in accordance with the treaty. The treaty, alongside the evidence of changes in Rwanda since the summer of 2022, enables Parliament properly to conclude that Rwanda is safe. My Lords, addressing other points raised in relation to this matter, and echoing what I said in response to my noble friend Lord Clarke, my noble friend Lord Tugendhat moved the sphere of literary references governing this bill in discussion in your Lordship's House on from Alice in Wonderland to George Orwell's 1984. My Lords, the point is, as I say, that not that the government is proposing that Parliament should legislate contrary to the findings of the Supreme Court, but that Parliament should pass a bill reflecting those changes and reflecting those decisions and acting upon them. We are acting on the Court's decision, my Lords, not overturning it. And my Lords, that, again, if I may respectfully echo a point made by my noble friend Lord Howard of Lympney earlier on, which again echoed his important speech at an earlier stage, that the theme of this matter, my Lords, is one of accountability. The accountability of Parliament and the government to face the consequences of its actions, of its decisions, before the electorate. My Lords, the importance of Parliament's judgment is the central feature of the bill, and many of its other provisions are designed to ensure that Parliament's conclusion on the safety of Rwanda is accepted by the domestic court. The treaty sets out the international legal commitments that the United Kingdom and Rwandan governments have made consistent with their shared standards associated with asylum and refugee protection. It also commits both governments to deliver against key legal assurances in response to the UK Supreme Court conclusions. We are clear that we assess Rwanda to be a safe country, and we are confident in the government of Rwanda's commitment to operationalising the partnership successfully in order to offer safety and security to those in need. My Lords, in answer to a point made by the Right Reverend Prelate, the Archbishop of Canterbury, whilst Sir Winston Churchill was, of course, instrumental in drawing up the body or making possible the creation of the European Convention, he did not say anything to alter the constitutional principle of the supremacy of Parliament, to which I've made reference. My Lords, returning to matters raised by the noble Lord Alton of Liverpool in his submission, he posed two questions. Firstly, in relation to the receipt of an answer to points made by committees of your Lordship's House. I've had that checked, and it is anticipated that answers to the Joint Committee on Human Rights and to the Constitution Committee will be issued by Wednesday. My Lords, the noble Lord also in his submission raised the matter of costs. Well, my Lords, the point surely is that it is not that doing nothing does not have costs in itself. We will doubtless return in the course of this stage of the bill's progress to the enormous expense inflicted on British taxpayers, running to billions of pounds a year by maintaining the status quo. It is that status quo that we seek to interrupt. I'll give way to the noble Lord.
Lord Stewart, on the question of cost, though, my point wasn't so much about the £500 million. My point was that the chair of the Home Affairs Select Committee in another place had said this was a staggering amount of money, but that it's being veiled by so-called commercial confidentiality. Will the noble Lord undertake that when he publishes his response to the Joint Committee on Human Rights and the Constitution Committee by Wednesday, but he'll also provide further details unpacking the so-called confidentiality of this £500 million.
In relation to that, if the Noble Lord would permit, I'll defer answering that question to a later stage. So, my lords, it is in order to prevent the current expenditure, the cost of housing asylum seekers is set to reach £11 billion per year by 2026 that the government proposes to act. My lords, as I said, we assess Rwanda to be a safe country, and we are confident in the government of Rwanda's commitment in that regard. I therefore invite the Noble Lord Clarke to withdraw his amendment, Amendment 2, and I'd also invite the Noble Lady Baroness Chakrabarti not to press her amendment. Were she so to do, I would have no hesitation in inviting the House to reject those amendments.
My Lords, I didn't succeed with my urging of brevity, but never mind. I'm grateful to all noble lords nonetheless, particularly for the tributes, the very worthy tributes to the noble Lord Cormac, and my noble friend Baroness Hennig. They were liberal patriots indeed. I remind your Lordship's House that the Prime Minister evoked the rule of law in his Downing Street address on Friday. But I'm grateful to the Most Reverend Primate for reminding us that in the post-war age, the international rule of law is part of that. I won't be tempted down the rabbit hole of the slightly unorthodox and creative version of the rule of law presented by the noble Lord Howard. Safe to say that he and his noble and learned friend, the Minister, effectively gaslit the Supreme Court. But they should have compared notes first, because one accused the Supreme Court of trespassing on the province of the executive, but the other, in his usual soft and seductive tones, said how much he respected our highest court. I guess one of them must be telling us the truth. But I think it was the noble Lord Tugendhat who gave the best response to both of them. This is post-truth legislation indeed. So I'm shocked, but if not surprised, by the response of the government. And for fear of some of the specious and nitpicking excuses around my slightly longer amendment, I will urge my noble friend, Lord Clarke, to press his very short and very simple, uncontrovertible amendment requiring compliance with the rule of law. And I beg leave to withdraw mine.
Is it your Lordship's pleasure that this amendment be withdrawn? The amendment is by leave withdrawn. Amendment 2, Lord Clarke.
I wish to attest the opinion of the House. I beg to move.
The question is that this amendment be agreed to. As many as are of that opinion will say content. Content. The contrary, not content. Not content. The question will be decided by a division. I will inform the House when voting is open. My Lords, voting is now open. Clear the bar. My Lords, the question is that Amendment 2 be agreed to. As many as are of that opinion will say content. Content. The contrary not content. Not content. The contents will go to the right by the throne, the not contents to the left by the bar. My Lords,
Order.
the question is that Amendment 2 be agreed to. My Lords, they have voted. Contents 274, not content 172. So the contents have it.
Order.
Amendment 3, Baroness Chakrabarty. Not moved. Amendment 4, Lord Hope.
There are 4 amendments in this group, all of which are in my name, and to which the noble Lords, Lord Anderson of Ipswich and Lord Jermyn and Baroness de Souza very kindly added their names as well. My Lords, they're all part of a single package, and they're designed to address what I suggest is a serious flaw in the wording of clause 1.2b. That clause states that the Act gives effect to the judgment of Parliament. The judgment of Parliament, I emphasise, that the Republic of Rwanda is a safe country. The word I'm concerned with is the word is. Now, as we were reminded in the last group, the Supreme Court expressed a view about this in November of last year. What it said, in fact, was that there are substantial grounds for believing that the removal of the claimants to Rwanda would expose them to the real risk of ill treatment by reason of refoulement. Now, Lords, your Lordships are being asked to reach a different judgment. In other words, your Lordships are being asked to declare that Rwanda is a country to which persons may be removed from the United Kingdom in compliance with all of its obligations under international law, and that it is a country as well from which a person will not be removed or sent to another country in contravention of international law. Now, it's not my purpose, for the purpose of these amendments, to question the right of Parliament to look at the facts again. The facts have changed since November 2022, which was the time when the facts were found on which the Supreme Court based its view. But I do think that if Parliament is to make a judgment on a matter of fact of such importance, great care must be taken in the use of its language. By its use of the present tense in Clause 1.2b, Parliament is asserting that from the date of commencement, that is the position now. And it's asserting, furthermore, that it will be the basis on which every decision maker will have to act in the future. That will be so, and each and every time a decision has to be taken forever, whatever happens in Rwanda, so long as the provision remains in the statute book. As the noble Lord Jugendaud said, the answer forever will be the same. And, my Lords, that's the point to which I wish to draw the Lordship's attention in these amendments. Now, Article 23 of the treaty provides that the agreement will last until 13th April 2027. But it also provides that it can be renewed by written agreement, so it may well last a good deal longer than that. And there is no sunset clause in this bill. That's the background against which I say a great deal hangs on the use of the word is. Now, Lords, the judgment your Lordships are being asked to make really is crucial to the safety and well-being of everyone, wherever they come from, who are at risk of being removed to Rwanda. Given what refoulement would mean if it were to happen for them, this could be for some a life or death issue. The question is, do we have enough information to enable us to judge that Rwanda is safe now and that it will be whatever may happen in the future? My Lords, I do not think so. I don't think I can make that judgment. And that's the reason why I've introduced this amendment and its counterpart, Amendment 7. What Amendment 4 is seeking to do is to remove the word is from that clause and replace it by the words will be and so long as. In other words, that it will be a safe country when and so long as the arrangements provided for in the treaty will have been fully implemented and are being adhered to in practice. I suggest that that is a more accurate way of expressing the judgment that your Lordships are being asked to make. What the point that it makes is that full implementation of the treaty is a prerequisite. The treaty itself is not enough, it has to be implemented. And that is what I'm drawing attention to. Without that, without the implementation which the treaty provides for, Rwanda cannot be considered to be a safe country, and in my submission, the bill should say so. Of course, there must be means of determining whether full implementation has been achieved and is being maintained. Now, that is provided for in my Amendment 7. I have based that amendment on the method which the treaty itself provides. The treaty provides for a monitoring committee whose members are independent of either government. We've been told that that committee already exists and is in action. So what I'm proposing should not delay the bill. And it's not my purpose to do so. I'm seeking simply the security of the view of the monitoring committee. The treaty tells us that the key function of that committee shall be to advise on all steps they consider appropriate to be taken to effectively ensure that the provisions of this agreement are adhered to in practice. And the government's policy statement in paragraph 101 says of the committee that its role is to provide an independent quality control assessment of conditions set out in the treaty. The government itself then accepts that entry into the treaty in itself is not enough. That is why it had asked for a monitoring committee to be set up, and that's precisely why my amendments are so important. The treaty must be fully implemented if Rwanda is to be a safe country. The point is as simple as that. So my Amendment 7 says that the treaty will have been fully implemented for the purposes of the Act when the Secretary of State has laid before Parliament a statement by the Monitoring Committee that the objectives of the treaty have been secured by the creation of the mechanisms which it sets out. Now, my Lords, if the ministers say to me that Rwanda is already a safe country, then it should be a matter of formality to obtain the view of the Monitoring Committee, and it should not detain the government for very long. Yeah. All I'm asking is we should have the security of the view of that committee to make it absolutely plain before we make the judgment or can make the judgment that Rwanda is and will continue to be a safe country. Then my amendment would require the Secretary of State to consult the Monitoring Committee every 3 months while the committee remains in force, and to make a statement to Parliament if its advice is that the provisions of the treaty are not being adhered to in practice. And if that is so, the treaty can no longer be treated as fully implemented for the purposes of the Act until the Secretary of State has laid before Parliament subsequent advice that the provisions of the treaty are being adhered to in practice. All of that is built around what the government has provided for in its own treaty, the work of the Monitoring Committee, on whose judgment I suggest we can properly rely. My Lords, finally and very briefly, my amendments 8 and 13 would make the directions to the decision makers in the clause conditional, clause 2, I should say, conditional on full implementation of the treaty. And also, I should make it clear that I intend to test the opinion of the House on my amendments 4 and, if necessary, 7 as well, if I'm not given sufficient assurances by the Minister. But I will not move my Amendment 8. That is because I do not wish to preempt the alternative qualification of Clause 2 proposed by my noble friend Lord Anderson of Ipswich, bearing in mind that his Amendment 12, which if moved, will preempt my Amendment 13. My Lords, I beg to move.
Amendment proposed. Clause 1, page 1, line 12. Leave out is a safe country and insert the words as printed in the Marshall list. The question is that this amendment be agreed to.
Sir, could I begin by adding my tribute to those already paid to the noble Lord Cormac. My particular knowledge of him is when I was briefly a member of the other place, my constituency abutted his, and we shared an agent, Mr. Clive Hatton. And I learnt from the noble lord the importance and the assiduousness with which he worked his constituency. There was no cause too small, no person too irrelevant that Patrick Cormac wasn't interested in looking after them, considering them, and I learnt a lot from him. Turning to the matter in hand, my lords, I want to comment on this group of amendments, and in doing so pick up on some of the remarks that I made in the debate we had on the noble and learned Lord Goldsmith's motion, which we debated on the 22nd of January. 2 points, my lords, and I've listened very, very carefully to the noble and learned Lord Herbert Craighead, who as an extremely eminent lawyer, I have to be respectful of. But I hope he'll forgive me if I have the impression that these amendments, together, collectively taken together, can have collectively the aim of rendering the bill, if not unworkable, inoperable. They're like a line of barbed wire fences. Each time you get through a barbed wire fence, there is another set of obstacles, another set of objectives to be fulfilled. Now, I recognise that there are a number of members of your Lordship's House who do not like this bill and do not think its approach is appropriate in any way. I think they're wrong, but obviously I respect that view. But why then greater efforts are not being made just to kill the bill? Well, of course, that is because, my lords, they know such an effort would fail. I don't want to get in the middle of a spat between the noble Baroness Jones of Moulscombe and the noble Lord Coker, but they're going to fail because His Majesty's Law Opposition would not support such a move. To wound is fine, but to kill would not be acceptable. And why, in turn, is this? Because away from the Westminster bubble, the overwhelming majority of the British people are firstly appalled at the loss of life in the Channel and what it stopped. I witnessed the child of 14 drowning last week. Second, are disgusted by the activities of the people smugglers. And thirdly, are exasperated or furious or both at what are, in large measure, economic migrants seeking to jump the legitimate queue. Now, this bill is currently the only game in town, and to do away with it would be immensely unpopular. My second point is, I find the continued assertion underlying this group of amendments is that somehow Rwanda as a country is untrustworthy unless every single T is crossed and I is dotted. And in this connection, members of your Lordship's House might like to read paragraphs 54 to 57 of the government's report on Rwanda, dated the 12th of December 2023. The Ibrahim Index of Government, an independent organisation, rates Rwanda 12th out of 54 African countries. And the World Economic Forum Global Gender Group, GAPS, makes Rwanda 12th. The UK, by the way, is 19th. And the World Bank scored Rwanda at 16 out of a maximum score of 18 in their quality of judicial processes. And finally, the World Justice Project on the Rule of Law ranked Rwanda first out of 34 sub-Saharan African countries. And those are points that I think tend to get overlooked in the debate that we're having, which tends to focus on our domestic arrangements. And that, my lords, takes me to my conclusion. The concept of the rule of law has featured prominently in our debate on this bill and will no doubt do so in the future. I'm not a lawyer, as many members of the House know, but nevertheless I strongly support the concept as an essential part of the freedoms we take for granted. But as I've also said in the past, the rule of law depends on the informed consent of the British people. And without that informed consent, the concept of the rule of law becomes devalued. So, my lords, when the House divides at the end of the debate, I respectfully say to members of your Lordship's House, we need to be careful not to conflate the fundamental importance of the rule of law with what I fear I see in these amendments, largely a measure of shadowboxing.
My lords, I follow the noble lord with much respect for him, for his contributions to your Lordship's House. The proposition made by my noble friend Lord Hope, which I support strongly, is that these amendments seek to give effect to the proposition that Parliament cannot judge Rwanda to be a safe country until the Rwanda Treaty has been and continues to be fully implemented. What does the government say? The government say that Rwanda is a safe country because the Rwanda Treaty has been achieved and shortly will be fully implemented. What are they afraid of? in these amendments, for they simply seek to provide insurance for the proposition made by the government about Rwanda. Well, to answer that question, I would invite the noble Lord the Minister to remind himself once again of the report dated the 17th of January this year of the International Agreements Committee, which was discussed at some length in previous debates in your Lordship's House. And I draw his attention particularly to paragraph 45, which sets out 9 further legal and practical steps, that's the term of art that's used, further legal and practical steps, which are required under the treaty, which will make, in the opinion of that committee, Rwanda a safe country, which operates the treaty in the way in which is intended by its words. And I would ask the noble Lord the Minister, who has been challenged to this effect before, to tell us quite specifically how many of those 9 requirements in that paragraph have now been implemented, which they are, and in relation to the ones that have not yet been implemented, when they will be implemented. And if the situation is that the government's optimism is such that, as the noble Lord Murray said in an earlier intervention in this debate, it's enough to go into the Rwandan Parliament and see that the treaty has been ratified, not the requirements in the committee's report. If it's enough for that to be a way of regarding the bill to be justified, what is the intellectual basis for that conclusion? Because I see none unless these requirements can be demonstrably implemented in full. Rwanda is not a safe country. And this insurance policy proposed by my noble and learned friend is exactly what's needed unless we are told of full implementation.
Of Lord Hodgson, because he suggested that those of us who have worries about this bill are in some way wanting to stop anything of this kind. I just want to make it absolutely clear. I don't have a theological or philosophic objection to the concept that you might have a system which involved some other country in order to deal with these problems. My problem is very fundamentally this. I hope in all the years as a minister and as a member of Parliament, I never told a public lie. And I am being asked here to tell a lie, because the government has told us that Rwanda is not a safe place at the moment, but is going to be a safe place. Indeed, the minister himself explained that to us. But they are asking us to say it is a safe place now. And at the same time, they are pointing to the Supreme Court and saying it is perfectly reasonable to disagree with the Supreme Court because the information which we now have makes a decision now different in kind from the one that they made, because they didn't have that decision. So evidently, it was perfectly right for the Supreme Court to say it wasn't a safe place then, but now we're in a different position. But the government hasn't provided us with any of the evidence which makes that different position tenable. All the government has done is to say, we have signed an agreement, that agreement is going through, and we are in the course of ensuring that that agreement is carried through in Rwanda. Now, I don't much mind how we do this, but what I want to be able to do is to vote to say Rwanda would be a safe place if all these things are carried through, and I want also to make sure that there is a mechanism for checking that, and I also want to make sure that if it should change, and after all, governments change. Africa has been known to have very significant changes. Indeed, the present government of Rwanda is a very, very hopeful change from what they had before.
So we need to have a mechanism whereby, should the situation alter, we would be able to deal with that. Now, normally, the courts would be able to deal with that, but the government has specifically excluded the courts, and therefore we need to have something of this kind. And I do think that the mover of these motions is absolutely right in saying they can all be carried through without holding up this act. So I want to ask my noble friend very directly, given this is not going to hold anything up, given that he's going to allow himself to tell the truth instead of not telling the truth, given that he can allow me to tell the truth, why doesn't he just allow us to do it? Many of the other issues are of high political and legal concern. This is a terribly simple, basic fact. Will you allow us to say that Rwanda is a safe place when you can provide the information to allow us to tell the truth? For goodness sake, let's tell the truth.
Well done, John. I also, as a member of the Joint Committee on Human Rights, was in Rwanda very recently. We had a packed program, and everyone we met told us that Rwanda is a safe country. And this includes women's rights, the LGBT organization. They all told us that that's how they felt. We were also told that Rwanda has the largest LGBT community in Africa, and many people from that community flee neighboring countries to come to Rwanda because they feel safe. Critics also tend to overlook the fact that Rwanda has one of the lowest levels of corruption in Africa, and that it is committed to the rule of law. It has more women in the participation in the labor market than in any countries in Africa. And the Supreme Court's decision, mainly based on the UNCHR report, failed to take many of those facts into account. The UNHRC representative we met admitted that Rwanda was at the forefront of improving its legal system, that Rwanda was a safe country as such, but not safe to accept relocated individuals from the UK, as the current system was not capable or experienced enough to deal with them. My lords, I need to point out that this was before this new agreement, where a lot of the concerns from the Supreme Court have been addressed. She also pointed out that refugees from the UK came from different backgrounds to refugees from neighboring countries. That comment was in direct contradiction to all the positive attitudes we witnessed. Everyone we met expressed genuine readiness to accept and welcome the refugees from the United Kingdom. The UNHRC representative conclusion was, which I found most revealing, was that the UK should accept all immigrants arriving to their shores rather than sending them off to Rwanda. But my lord, this is unrealistic to say that UK has a responsibility to accept all the asylum seekers, particularly if they come to our shores for economic reasons, and line up the pockets of traffickers. We are one of the most generous countries when it comes to refugees, but we have a responsibility towards our citizens, and this includes securing our borders to ensure that no one takes advantage of our system. My lords, most of the people we met in Rwanda were surprised, if not deeply hurt, by the negative attention their country has received from both houses and the media. And I have to tell you that I was embarrassed. I felt that here we are criticizing that country that has had the terrible genocide in the past, and in the past 30 years they have done so much to improve everything, and they are so willing to accept new migrants. I was embarrassed. And to be honest, Kigali is a beautiful country. I fell in love with it. A beautiful city. It is clean, it is tidy, it is well organized, it's a young population full of optimism, looking forward to their future. And I wouldn't mind living there, to be honest. And my lords, I would actually recommend that a lot of you who criticize Rwanda would actually go there and check for yourself and decide what you think, rather than making observation on hearsay and possibly, yeah.
Before the noble lady sits down, she referred to LGBT situation in Rwanda. Before the noble lady responds, let me perhaps pose my question. Could she indicate to the House the LGBT organisation that she met with?
We met two of them. We met the Rwanda sorry, my memory is not so good, you see. Rwanda Women's Network, which was very actually interesting. Hope and Care Organization, Rwanda Men's Resource Center, and the other organization was My Rights Alliance organization. And they're both campaigning for LGBT rights.
I thank the noble lady for that, and I won't detain the House any longer, but I think it's important to put on the record, and I say this with some knowledge of Rwanda, having been the chief election observer for the European Union in Rwanda in 2008 and subsequent knowledge since. However, she quoted the Hope and Care organisation, and it does indeed do a great deal of work, but I thought your lordships should be aware of a recent quote, and I won't name the individual for fear of placing anyone at risk, but it is on my records, if anyone needs it, and I quote, "Homosexuality is not criminalised in Rwanda, but many LGBTI people keep their sexuality and gender identity secret in an attempt to avoid rejection, discrimination and abuse, which in the long run inevitably denies them their basic human rights." Close quotes.
I just want to comment. I'm not an LGBT, so I have no idea, but from the evidence we heard, apparently in the older generation or in the countryside, it's also a little bit frowned upon, probably like in the United Kingdom. But that similarly in Kigali, the capital, we were told that actually two men walking in the street holding hands is absolutely fine. This was the report we received.
Again, I won't detain the House, but I will refer to this particular situation and the expression of one's sexual identity in a later grouping, Group 5. Thank you. I thank your lordships for your patience.
Might I briefly add a few comments to the remarks made by the noble Lord Gummer? In his remarks, the noble Lord Hodgson said, and it is true, that there is a lot of concern and anxiety about the whole issue that we are discussing this afternoon. My lords, probably in this chamber, there is nobody who knows less about Rwanda than I do. And I dare say I am representative from the nation as a whole. It would, I think, be a great deal of advantage for everybody, because the wider world is very concerned about this, and we've been talking about this from the perspective of this chamber. If you look at it from the perspective of the wider public, to have something along the lines of what the noble Lord Hope and the noble Lord Anderson are advocating would be very helpful in trying to allay wider public concern. Because it seems to me, my lords, and I'm sure we all regret it very much, But the way the world is now, the fact that government gives it the thumbs up does not necessarily instill great confidence in the wider public.
My Lords, I think I'd like to start by saying to Lord Deben why I come to the same conclusion about these amendments, but perhaps from a different perspective, because, as you know, these benches voted against the bill in principle, but that doesn't mean to say that we, having not won that argument, that we won't support changes to the bill in ways which mitigate the problems which we still see with this bill. It is worth reminding the House of the decision that this House took in respect of the treaty, which, as it said, we will not recommend the treaty be signed until these conditions are in place. Now, as you know from the standing orders of this House, that is a resolution of this House, and it is the view of this House. So simply, these amendments are seeking to amplify and to recognise the decision of this House which is in place at the present time. Because if it's not in place, then we're going to be asked to do that fictionalised thing, which is basically to change our minds from what we said before, that we need to have those in place before we can see it as safe, and now we would change our minds and we would have to do it simply because the bill is before us. So what this group of amendments does is to recognise that we need to have them in place before the consideration this House has already given can be reversed. And I must say to the noble lady that safe in respect of a country is not about the beauty of the country or the nature of the people. It's about the structures and the systems which they have in place in order to meet their obligations and meet obligations for refugees as we have laid out. Now, my Lords, given that the courts have made a decision of fact on the safety of Rwanda, it's deeply problematic that the government wants this Parliament to overturn its own decision and declare the opposite. And if that were the case, we would have thought that they would be better off going back to the courts to review the evidence and coming to a finding of fact if it believed the situation had changed. But as the United Nations Council for Public Affairs and the recent announcement that we've heard from them last Friday said, this bill will unduly limit judicial independence by requiring judges to treat Rwanda as a safe third country now and in the future, regardless of any evidence to the contrary before them. Now, it's clear that the terms of the treaty have not been met. That's what this House says. That is the resolution of this House. They need to be met before the requirements of the treaty are satisfied. The mechanism by which the government is asking Parliament to declare Rwanda safe is the treaty. Now, the Minister confirmed during committee stage that indeed the safeguards, as outlined in the resolution of this House, are not yet in place, but are being worked towards. The Hansard of the 12th of February, day one, my noble friend Lord Purvis asked, can we pursue the issue that the Minister had said, is what the Rwanda government are working towards putting safeguards in place? That means they're not currently in place. Is that correct? And Hansard says that Lord Stewart of Dillon, noble Lord the Minister, noble Lord Norman said it must do. Now, this afternoon, letters have been delivered to members who took part in these debates, and I apologise for having to look on my phone because these letters, which related to the committee of this House on this bill, were only delivered by electronic mechanisms after we had started discussing the report. Now, that is not a way I think this House should be treated. If we want the evidence upon which we can make decisions, we should have had it in time to be able to make further progress. But anyway, my Lords, I have to turn it sideways because it is very small writing, but I can do my very best. It says in one paragraph about whether these matters are in sight. It said the Rwandan Treaty, the UK-Rwandan Treaty, sorry, I've got to find the right sentence, it keeps jumping too small, the UK and Rwandan governments will continue to work closely together to implement all the measures under the treaty and prepare to operationalise the partnership. So quite clearly, the facts that were required by this House are not there at present. It's almost, and I do like to quote Lord Purvis, his analogy, it's like saying, right, gentlemen, ladies and gentlemen, we're going by plane and we're working towards making the plane safe. Now, if you think about it, that's where we are at the present moment. Would you get into that plane? Probably not. You'd be foolish to do so. But if you did get into it, you have no guarantee that it would be capable of, first of all, flying or even dropping out of the air. So these resolutions, these amendments, are absolutely clear that we must put them in place. They've already been agreed by this House, who've made it clear the conditions that we as a House place on the treaty are to be adhered to. They make it clear that the conditions and procedures they must adopt to satisfy the House both before and after deportations can take place. They are sensible. They are what the House requires in order to fulfil the requirement of the decision that we took on the matters of the treaty. My Lords, I support.
My Lords, I do urge noble Lords to use some common sense. It is inconceivable, if this Act is passed, for the first few months, regardless of whether all the conditions of the treaty have been implemented, that Rwanda, under the full spotlight and glare of international publicity and the attention of this press, that Rwanda will not implement carefully and considerately, will not refool anyone that we send them. The reason for having all the things in the treaty is for the period after the initial spotlight has been turned off, after attention has waned. Then it's important to have all those considerations in place. It isn't initially, and no one could really imagine that we send someone out and within a few weeks they're sent by Rwanda to some unsafe country. It won't happen. We know it won't happen. But it is very important that we get this happening soon. Not only use common sense, but be merciful. Because the longer we delay, the more people will come across the channel and the more will die.
My Lords, I wonder whether the Minister would care to comment on whether he agrees with the Noble Lord Lilly's analysis of the status of this bill which we're debating here. Lord Lilly said it's inconceivable that there would be any refoulement, and that it's okay to proceed without the various recommendations in place, because in the longer term they would need to be in place, because it was in the longer term. I think Lord Lilly was suggesting that there may be justification in the suspicions which are being raised. I think that's the point which the noble Lord Lilly was making. But, my Lords, I want to speak very briefly to say that I would like to thank the noble and learned Lord Hope for tabling these amendments and his very constructive communication ahead of putting them down. There was a clear interest at committee stage of the bill in developing a mechanism to ensure that the terms of the treaty are adhered to and continue to be adhered to. And I hope that the House will see that there's a value in how Lord Hope has integrated these ideas into the amendments tabled here. Amendments 4 and Amendment 7 together provide a clear framework for ensuring the ongoing safety of Rwanda, rooted in the terms of the treaty which the government itself has negotiated. My Lords, I'm not going to say any more because I think the noble and learned Lord very clearly set out the terms of his amendments.
My Lords, I'd like to thank all noble Lords for their contributions. The partnership between the UK and Rwanda is rooted in a shared commitment to develop new ways of managing flows of irregular migration by promoting durable solutions, thereby breaking the existing incentives that result in people embarking on perilous journeys to the UK. And we saw again how perilous those journeys are only last week, as my noble friend Lord Hodgson noted. The UK and Rwanda share a vision on the need for the global community to provide better international protection for asylum seekers and refugees, emphasising the importance of effective and functioning systems and safeguards which provide protection to those in most need. Noble Lords will know that Rwanda has a long history of supporting and integrating asylum seekers and refugees in region. For example, through its work with the United Nations High Commissioner for Refugees to host the Emergency Transit Mechanism. It has also been internationally recognised for its general safety and stability, strong governance, low corruption and gender equality. Again, as my noble friend Lord Hodgson noted, and I thought as noble Lady Baroness Mayer gave us her very welcome perspective on her recent visit. And I would say gently to the noble Lord German, I heard a great deal in her comments about structures and systems. My lords, as the noble Lord Hope of Craighead has explained, these amendments seek to only allow Parliament to deem Rwanda to be safe so long as the arrangements provided for in the Rwanda Treaty have been fully implemented and are being adhered to in practice. The UK government and the government of Rwanda have agreed and begun to implement assurances and commitments to strengthen Rwanda's asylum system. In advance of agreeing the treaty, we worked with the government of Rwanda to respond to the findings of the courts by evidencing Rwanda's existing asylum procedures and practice in standard operating procedures relating to and reflecting the current refugee status determination and appeals process. Amendment 7 imposes a duty on the Secretary of State to obtain a statement from the Independent Monitoring Committee confirming that the objectives specified in Article 2 objectives of the treaty have been secured. My lords, this is unnecessary. The government will only ratify the treaty in the UK once we agree with Rwanda that all necessary implementation is in place for both countries to comply with the obligations under the treaty. We have assurances from the government of Rwanda that the implementation of all measures within the treaty will be expedited, and we continue to work with Rwandans on this. Just last week, the legislation required for Rwanda to ratify the treaty passed the lower house of the Rwandan Parliament on the 28th of February, and it will now go to the upper house, as my noble friend Lord Murray noted in the previous group. Once ratified, the treaty will become law in Rwanda. So it follows that the government of Rwanda would then be required to give effect to the terms of the treaty in accordance with its domestic law as well as in international law. My lords, the bill provisions come into force when the treaty enters into force, and the treaty enters into force when the parties have completed their internal procedures. These amendments therefore confuse the process for implementing the treaty with what is required for the bill provisions to come into force. This bill builds upon the treaty between the UK and the government of Rwanda, signed on the 5th of December 2023. The bill reflects the strength of the government of Rwanda's protections and commitments given in the treaty to people transferred to Rwanda in accordance with the treaty. The treaty, alongside the evidence of changes in Rwanda since the summer of 2022, which was published in January of this year, will enable Parliament to conclude that Rwanda is safe, and the new bill provides Parliament with the opportunity to do so. And I would say to my noble friend Lord Deben that that is the truth. Turning to the points raised.
Everything that he says, I accept. But it's all about what's going to happen in the future. What he's asking me to do is to say that what is going to happen in the future has happened now. That's the only argument. And he wouldn't ask me to do that in any other circumstances. Could he explain why I've got to do it now?
Because of the point I made.
Well, my lords, I think I've been extraordinarily clear on this particular subject. As I said, the bill provisions come into force when the treaty enters into force. The treaty enters into force when the parties have completed their internal procedures. And these amendments, therefore, confuse the process for implementing the treaty with what is required for the bill provisions to come into force.
Well, my lordship, he says it will confuse it. It's actually perfectly straightforward. If everything happens as he says it will happen, and I hope it does, because I don't object to the safe country policy that's being pursued if you can find a safer country. But if everything happens as smoothly as he says it's going to do, then the Monitoring Committee will presumably confirm that it's happened. Why is he resisting it, except to save the Secretary of State having to send a letter asking for the Monitoring Committee's principle? Why is this amendment a threat to the government's stated policy?
I would say to my noble friend, I'm about to come on to the workings of the Monitoring Committee in great detail, so if you will bear with me. So turning to the points raised with regards to introducing a duty on the Secretary of State to consult with the Monitoring Committee every 3 months during the operation of the treaty. My Lords, this committee is independent of both the UK and Rwandan governments. It was always intended to be independent in order to ensure that there is a layer of impartial oversight of the operation of the partnership. Maintaining the committee's independence is an integral aspect of the design of the policy, and as my noble friend Lord Stewart of Durlton set out, the treaty enhances the monitoring committee's role. It will ensure obligations to the treaty are adhered to in practice, as set out in Article 15(4)(b). It will report to the Joint Committee, which is made up of both UK and Rwandan officials. As per Article 15(4)(c) of the treaty, the Monitoring Committee will make any recommendations to the Joint Committee which it sees fit to do. Therefore, these amendments are both unnecessary and risk disturbing the independence and impartiality of the Monitoring Committee.
Confirm to the House that the Minister, which I assume means the Secretary of State for Home Affairs, will not seek to bring this bill into force, or the Act into force, until he is satisfied that all the provisions of the treaty have been implemented and are being properly operated.
Noble and learned Lord, that I think I've already answered that. The bill provisions come into force when the treaty enters into force, and the treaty enters into force when the parties have completed their internal procedures.
That's not quite an answer to my question. Could he give the House an assurance that the Home Secretary will only bring the treaty into force once he is satisfied the treaty's provisions have been implemented and it's operational?
I disagree. I'm afraid that is an answer to this particular question. I think it is. To assure noble lords further, the Joint Committee met on the 21st of February to discuss implementation and readiness for operationalisation, and as set out in the published terms of reference for the Joint Committee, minutes will be produced after each meeting for agreement by the co-chairs. The Monitoring Committee will undertake daily monitoring of the partnership for at least the first 3 months to ensure rapid identification of and response to any shortcomings. This enhanced phase will ensure that comprehensive monitoring and reporting takes place in real time. As I set out in earlier debates, during the period of enhanced monitoring, the Monitoring Committee will report to the Joint Committee in accordance with an agreed action plan to include weekly and bi-weekly reporting as required. During this enhanced phase, the Monitoring Committee will place particular emphasis on monitoring asylum procedures, asylum case assessments, and any asylum decisions made in this timeframe. The Monitoring Committee will ensure that decisions are objective and based on a legally sound foundation in accordance with international laws and convention. The following minimum levels of assurance have been agreed by the Monitoring Committee for the enhanced phase. 2 visits to the UK to see the selection process, observing 2 boarding and 2 disembarkations, observing 3 induction sessions, weekly visits to accommodation and reception centres, monthly visits to health facilities and education, observing education and language training sessions, observing interviews, observing appeal hearings, reviewing the process and paperwork for all individuals relocated to Rwanda in this phase, monitoring the status of people relocated to Rwanda, captured through the quarterly reporting process and visits to resettlement areas, review a sample of at least 25% of complaints, including all serious incidents, investigating all complaints received directly, interviewing on a voluntary basis a sample of 1 in 10 relocated individuals at various stages of the process. The published terms of reference are accompanied by a detailed monitoring plan as agreed by the Monitoring Committee, which was published on the 11th of January. These documents provide a comprehensive and transparent framework for the operations and procedures of the Monitoring Committee, starting from the immediate departure period of the first cohort of relocated individuals and including the details of the enhanced initial monitoring phase. The plan provides an overview of the Monitoring Committee's specific activities, monitoring techniques, and the personnel involved. It also outlines reporting procedures and...
I'm most grateful to the Noble Lord who's given us a great deal of new information about the Monitoring Committee, but all that he's told the House demonstrates the Monitoring Committee is extremely well placed to provide the government with the information it needs to act as in my noble and learned friend's amendment. So what's
holding it back. The fact of the matter is that the Monitoring Committee has no means of reporting to this Parliament, but the government does. And that is what this amendment suggests is the right thing to do.
What the Noble Lord says, but I think I've answered again this in considerable detail now. My Lords, this...
The more detail the Noble Lord gives about the virtues of the Monitoring Committee, the stronger his argument is in favour of the amendment proposed to this House by Lord Hope. This briefing he's been given is totally contradictory to the conclusion that he's trying to invite us to reach.
I'm afraid I disagree again. My Lords, as set out in the monitoring plan, the Monitoring Committee will ensure that there is a daily presence of the support team on the ground through the initial enhanced phase. And for the enhanced phase, a minimum of 2 Monitoring Committee members will be actively engaged in the monitoring. My Lords, the implementation continues at pace, including the support team for the Monitoring Committee and the new appeals body. So I would like to put on record my thanks to all officials, including those in the Government of Rwanda, for all their hard work in implementing the treaty and delivering the crucial partnership. The partnership is one important component of a much broader bilateral relationship. We cooperate closely with Rwanda on a number of issues, including the Commonwealth, climate change, education, trade, governance and conflict issues, and delivering a successful and long-standing development partnership. So to conclude, we have agreed and begun to implement assurances and commitments to strengthen Rwanda's asylum system. These assurances and commitments provide clear evidence of the Government of Rwanda's ability to fulfil its obligations generally and specifically to ensure that relocated individuals face no risk of refoulement. I therefore respectfully ask the Noble Lord.
Before the Noble Lord sits down, can I return to the question I asked him? Will he now tell the House which of the 9 provisions highlighted in paragraph 45 of the International Agreements Committee's report are now completed?
This has already been discussed. The lower house of the Rwandan Parliament has only passed its treaty ratification earlier this week, and as I have just tried to explain, implementation continues at pace. I don't have the very specific information he requires yet, but as I've also explained, we will not be implementing until all of the treaty obligations are met. I would therefore respectfully ask the Noble Lord to not move his amendment, but were he to do so, I have no hesitation in inviting the House to reject it.
I'm very grateful to all Noble Lords who have taken part in this debate. I don't want to take up time by going over the issues all over again, but I wanted to pick up just 2 points made by the Noble Lord, Lord Hodgson of Astley Abbott. First of all, I think he suggested that my amendments were treating Rwanda as a country which is untrustworthy. The Lords, I absolutely refute that. When I introduced these amendments at committee, I made it absolutely clear that I do not for a moment question the good faith of Rwanda, and I remain in that position. I absolutely understand that both parties to this treaty are treating with each other on that basis, and certainly I'm not in any way questioning good faith or indeed the commitment for Rwanda to give effect to the treaty. What I'm talking about is its implementation. The second point is, I think he said that my amendment would make the bill unworkable. Lord, I simply do not understand that. I cannot understand why relying on the word of the Monitoring Committee in any way undermines the effectiveness or purpose of this bill. For these reasons, my Lord, I wish to test the opinion of the House.
I must advise the House that if Amendment 4 is agreed to, I cannot call Amendment 5 due to preemption. The question is that Amendment 4 be agreed to. As many as are of that opinion will say content. Content. The contrary, not content. Not content. The question will be decided by a division. I will advise the House when voting is open. My Lords, voting is now open. Clear the bar. The question is that Amendment 4 be agreed to. As many as are that opinion will say content?
Content.
The contrary, not content?
Not content.
The contents will go to the right by the throne, the not contents to the left by the bar. The question is that Amendment 4 be agreed to. My Lords, there have voted contents 282, not contents 180. So the contents have it.
What's correct? It was 100 last time, 100.
My Lords, Amendment 4 having been agreed to, I cannot call Amendment 5 due to preemption. Amendment 6, the Baroness Chakrabarti.
So, my Lords, I apologise. I'm slightly confused because I thought there was another vote
That puts you in the majority.
in the previous group, but apparently not. So, in the absence of my noble friend Lord Blunkett, I'll briefly open this group. I share Amendment 6. No. What am I? Well, then why am I on my feet? Not
Does the noble Baroness wish to not move her amendment?
Yeah, not moved.
Not moved. It's not. I'm not moving Amendment 6. That's right.
Amendment 6 not moved. Amendment 7, the Lord Hope of Craigie.
I wish to test the opinion of the House on this amendment.
The question is that Amendment 7 be agreed to. As many as are of that opinion will say content.
Content.
The contrary, not content.
Not content.
The amendment will be decided by division. I will advise the House when voting is open. My Lords, voting is now open. Clear the bar.
Order. The question is that Amendment 7 be agreed to. As many as are of that opinion will say content. Content. The contrary not content. Not content. The contents will go to the right by the throne. The not contents to the left by the bar. question is that Amendment 7 be agreed to. There have voted contents 277, not contents 167. So the contents have it. My Lords, before I will explain the order of preemption, because it's important. If Amendment 8 is agreed to, I cannot call Amendments 9 to 11 due to preemption. If Amendment 9 is agreed to, I cannot call Amendments 10 to 11 due to preemption. If Amendment 10 is agreed to, I cannot call Amendment 11 due to preemption. I will remind you at the relevant points. I now call Amendment 8. I would remind you for Amendment 9 that if it's agreed to, I will be unable to call Amendments 10 to 11 due to preemption. Amendment 9.
My Lords, I rise to address Amendments 9 and 12 in my name and those of the Noble Lord Carlisle, the Right Reverend Prelate, the Bishop of Manchester, and the Noble and Learned Lord Clarke of Nottingham. I will be brief because these equivalent amendments were discussed in detail in committee. I should say I'm also very grateful to the Noble and Learned Lord Hope of Craighead for how he has dealt with the issue of preemption, which I hope, your Lordships willing, may allow both groups of amendments to stay alive. Amendment 9 would allow ministers, officials and courts to depart from the presumption that Rwanda is safe when presented with credible evidence that it is not.
Amendment 12 would remove various detailed barriers to that course. Their combined effect is to reverse two of the most revolutionary aspects of this bill, and I do not use that word in a positive sense. They are the requirement that decision makers, including courts, must stop their ears to any evidence that does not agree with the government's position, and the requirement that they should do so for an indefinite period, even if things in Rwanda should, as we all hope they will not, take a turn for the worse. If noble lords are in any doubt as to how truly remarkable Clause 2 is, I would invite them to look at subsection 4. It doesn't matter how compelling your evidence is of what could happen to you and people like you when you get to Rwanda, it must not even be considered if it questions the proposition that Rwanda is safe. And at subsection 5, which sets out the legal principles that have to be ignored in order to make this clause work. Not just the Human Rights Act and international law, but, and I quote, any other provision or rule of domestic law, including any common law. An insight into the sheer range of legal protections, ancient and modern, that may have to be disregarded in the interests of avoiding the impartial scrutiny of the courts. If Rwanda is safe, as the government would have us declare, it has nothing to fear from such scrutiny. Yet we are invited to adopt a fiction, to wrap it in the cloak of parliamentary sovereignty, and to grant it permanent immunity from challenge, to tell an untruth and call it truth. Why would we go along with that? Clause 2 of the bill, my lords, takes us for fools. Subject to anything the minister may say, when these amendments are called, I fully expect to test the opinion of the House. I beg to move.
Amendment proposed, Clause 2, page 2, line 34. At the end, insert the words as printed on the Marshall list.
Oh, sorry.
My Lords, I rise to offer support to the noble Lord Anderson of Ipswich, and I'm really glad that this evening I've started to understand the processes of the House of Lords, having been here for only 8 years. So I will not speak to Amendment 6, which had to be withdrawn in order to vote on Amendment 7, even though Amendment 6 was in Group 3. But there we go. I can be even briefer than I intended to be by just saying when something is a nonsense, it remains a nonsense at whatever stage we happen to be voting on. And that crucially, and in terms of what Lord Anderson has rightly said, that when circumstances change, most people change their minds. But if minds are not allowed to be changed when circumstances change, then we're all extremely foolish. I heard the noble Lord Howard on the radio this morning explaining in great detail why Parliament had primacy over the courts, and in many respects, as with the doctrines of Lord Jonathan I can't get my teeth round. Sumption. I agree, but actually what happens when the government step outside the norms of international conventions which Parliament has ratified and signed up to, then the courts obviously continue to have a substantial role, because that's the checks and balances that we built in. So what we're trying to do, I think, this evening is to try and make some sense of a nonsensical piece of legislation, and no doubt the House of Commons will just nod through the government's rejection of these amendments. But actually, in time to come, when historians look back, I think they will ask the question, where were you and what did you do? And if you can't answer that in a way that makes you feel comfortable about your grandchildren seeing it, then don't do it.
Lords, what a privilege to follow my noble friend Lord Blunkett, and I apologise to your lordships for my mistakes earlier on with standing up at the wrong time. I have Amendment 19 in this group with the Noble and Learned Lady Baroness Hale of Richmond, the Noble Viscount Hailsham, and the Right Reverend Prelate, the Bishop of St Edmundsbury and Ipswich. However, I commend all other amendments, and in particular, I commend the simple and clear amendments of the Noble Lord Anderson of Ipswich. Because while we suggested a rebuttable presumption, his formulation that a finding of safety may be displaced by credible evidence to the contrary is clearer and even more attractive. So I do urge the Noble Lord Anderson, as he's indicated, to please press his amendment to a vote. And in concluding, I merely flag as a sort of advert for Wednesday that it is very, very important that as many noble lords as possible could be here early on Wednesday to support Amendment 33, which is the new Clause 4. That it will be debated and pressed then, because without that amendment that restores the general jurisdiction of the courts, other amendments, even these ones, could well be illusory. The purpose, as I say, to restore the jurisdiction of courts and tribunals, to decide what are the facts based on the evidence before them, including to invoke this rebuttable presumption, is what our courts are for, despite all the dancing that we heard before about novel interpretations of the rule of law. Our courts are admired for that jurisdiction all over the world. That is what we mean by the rule of law.
Rise briefly to support what the Noble Lord Anderson has said, and of course the Noble Baroness. I signed her Amendment 19. I do think that this House should try to insist that if the facts change, a mechanism is provided to the courts to reassess the situation. Anything else is profoundly unjust, and therefore if the Noble Lord Anderson moves his amendment, I should be supporting him.
My Lords, as well as supporting the Noble Lord Anderson, I rise to speak to Amendment 16, which seeks to minimise the risk of torture arising from the bill and to safeguard those who are torture survivors. I'm grateful to the Noble Baroness Lady de Souza and my noble friend Lord Cashman for their support, and they'll speak to the first part of the amendment while I focus on the second. We brought it back because of our dissatisfaction with the response from the Noble and Learned Lord the Minister in committee, and we hope we might do better now, given the existential importance of torture, which represents one of the most serious of human rights violations. We know from the work of organisations such as Freedom from Torture and Redress, whose help I'm grateful for, that a good number of the asylum seekers in line to be sent to Rwanda will have survived torture. We also know, including from a recent report from the Mental Health Foundation, that the high incidence of mental health difficulties among asylum seekers, the risk of which is increased by traumatic experiences such as torture. These difficulties can only be exacerbated by removal to Rwanda. My Lords, in committee, the Minister pointed out that an individual could challenge removal on the grounds of their individual circumstances, but Freedom from Torture warned that providing in the time available the necessary compelling evidence to meet what is the exceptionally high bar set by the test means that it does not offer torture survivors an effective safeguard. Indeed, the Minister himself admitted that successful claims on this basis are expected to be rare, and that might have implications for some other amendments. In response to my questioning about what mental health support will be available to torture survivors in Rwanda, the Minister referred me to Article 13 of the treaty, but that refers only to the special needs of victims of modern slavery or human trafficking. I can find no reference to the needs of torture survivors. My noble friend Lady Kennedy of the Shores interjected that the mental health situation in Rwanda is very poor, with high levels of mental illness, but very few suitably trained medical professionals. Since then, I've been referred to WHO's 2020 mental health profile for Rwanda. This confirms the low level of provision and seems to show that there are no outpatient mental health facilities. If this continues to be the case, Would traumatised torture survivors have to be admitted to a mental health unit to obtain any support? As was noted in committee, civil society remains weak and therefore is unlikely to be able to step in. More recently, last October, a press release from Interpeace, while commending the efforts the Rwandan government have made in this area, warns that the country still faces challenges such as the scale of mental health needs that outstrips the capacity of available professionals, low awareness and knowledge of mental health issues, poor mental health infrastructure. My Lords, from his responses, it would appear that the government simply don't know what support will be available and have made no attempt to find out. Yet they are happy to condemn this highly vulnerable group to a life in a country that, with the best will in the world, is ill-placed to provide that support. Of course, ideally, I would want the government to accept the case for not sending torture survivors to Rwanda. But at the very minimum, I would ask the Minister, I'm not quite sure which Minister I'm speaking of, I would ask the Minister to take this issue back to the Home Office and give an undertaking that he will ask his colleagues to talk to the Rwandan government about support for torture survivors and, if necessary, provide the necessary resources to ensure that support is available, perhaps earmarking part of the enormous sum to be paid to Rwanda identified by the NAO.
What needs to be said about the risk of torture and inhumane treatment has already been set out by the Noble Lady, Lady Lister. I simply wish to emphasise the credibility of the reports of ongoing torture, of even mild political dissenters that continues to this day in Rwanda. Nor, my Lords, does freedom of expression and association exist in Rwanda, however narrowly the term is defined. However, the genocide ideology law is very broadly defined and carries now criminal sanctions. The criminal code has recently been expanded to include creating a hostile opinion of Rwanda by criticising the government. So these irrefutable reports indicate that Rwanda does not comply with the international obligations under various UN conventions, including the Convention Against Torture, and this can only add to the evidence that at present Rwanda cannot be regarded as a safe country.
Grateful to the Noble Lord Anderson of Ipswich for sponsoring amendments 9 and 12, to which I've added my name, that take up matters that we also raised at committee stage, myself and the Noble Lord Carlisle. This particular evening, Rwanda may be the safest country in Africa, for all I know, but we have seen over the last few years a number of military coups, a number of takeovers across African countries to enshrine in legislation the notion that Rwanda will remain safe, whatever, seems to me to beg a belief. Who knows what that state that country may be in 6 months' time, in 12 months' time? Who knows how safe it will be then? The courts need to have the ability to take new facts into consideration, to recognise that Rwanda may not be the same in a certain number of weeks or months' time or years' time as it was on this particular evening at the beginning of March 2024. We must have that flexibility. So I hope Lord Anderson will press these amendments for division, and I will support him in the lobby if he so does.
My Lords, as a member of the JCHR delegation, I had the benefit of visiting the very hospital in Kigali, which will provide mental health support to relocated individuals. It was, my Lords, an impressive experience. That particular hospital has very capable psychiatric and psychological care. And this is perhaps unsurprising given the context in which Rwanda finds itself. This is a country which 30 years ago was caused mass trauma as a consequence of the genocide against the Tutsi, which cost 800,000 lives in Rwanda. You can imagine, my Lords, the impact that has on the relatives and those who knew those 800,000 people. Mental health is a widely understood and widely acknowledged health issue in Rwanda. The community schemes to work on mental health are abundant. This is a country which understands mental health. The points raised against Rwanda on the basis of mental health are, in my view, unfounded, and I do not accept the contentions advanced by the noble Baroness Lady Lister and the noble Baroness Lady de Souza.
I just want to follow the noble Lord Murray in terms of him trying to portray the issue of mental health provision within Rwanda. And to use his words, the understanding of the illness may be there and the provision, he says, is significant. My Lords, I just want to point out that in the UK, in terms of psychiatrists, there are 13,170, which equates to 1 for every 5,200 citizens. In Rwanda, what the noble Lord Murray didn't tell the House is that there are only 15 psychiatrists in the whole of Rwanda, which equates to 1 for every 953,000 people. So the provision clearly isn't on the ground. The number of clinical psychologists are not known, but the latest evidence is it probably runs into less than 200. The people who are vulnerable and who are critically scarred mentally will need the use of both psychologists and psychiatrists. And the fact is they are not there on the ground. So when Lord Murray presents his views of what he has seen, they are important, but they must be put in the context of exactly what provision is on the ground in Rwanda. And mental health, even though the government may wish to see it as a provision that is important, the fact is the provision isn't on the ground to treat people already in Rwanda, never mind people who will be going from this bill.
My Lords, as I said earlier when talking to a group of amendments, I spent a great deal of time in Rwanda, and of course, as anyone knows who visits there, the first thing one does is one goes to the Genocide Museum to look at the faces of those who were lost, to look at the skulls that are there to remind us that it should not be forgotten. Indeed, my Lords, the genocide strikes at the very psyche of Rwanda and laws within Rwanda. And it is because of our very deep concerns and for the progress that Rwanda has made that we put forward these amendments based on safety for whom we believe are amongst the most vulnerable in the world. My name has been added to the amendment in the name of my noble friend, Lady Lister. And she and Baroness de Souza have set out, I believe, adequately the reasoning for this amendment. So I will not go into further detail. But, my Lords, I will say this. There is evidence of ongoing torture in Rwanda. That was made plain to us during the committee stage from the intervention of my noble friend, Baroness Whittaker. It's been made plain to us by the briefings that we have received from Redress, amongst others. And I make these criticisms, my Lord, with a deep, deep regret, because I believe the UK government cannot be easily forgiven for the harsh spotlight it has put on a country that has striven to improve since that genocide and continues to improve. And that is why I say with the greatest respect that our concerns are for the most vulnerable, not only who will go there, but will pull upon the resources that are there already for those in need. So therefore, my Lords, I also want to say how much I think the House, if the noble and learned Lord Anderson puts his amendments to the test of the House, I do hope your Lordships will support them. As I've said before, like a cheap curry repeating myself, they are so sensible, and that is probably the reason why the government will encourage us to reject them. Finally, my Lords, this is about supporting, as I said, the most vulnerable. This group of amendments is about supporting those most in need. If we cannot offer support and consideration to those most in need, my Lords, then I have to ask myself,
what kind of country have we become, and what principles do we serve, except perhaps naked self-interest?
Lords, I should like to speak to two amendments in the name of the Baroness Meacher and myself, which are Amendments 23 and 27, and they deal with Clause 4, Subclause 1, A and B, and it relates very simply to compelling evidence. If I may say to your Lordships, that in order for someone to be found requiring particular individual circumstances, the threshold is quite simply too high. And so the point of these two amendments is to take away the word compelling.
Very good.
About Lord Anderson's amendment number 9, which on the face of it seems extremely reasonable. Whenever, if new clear evidence emerges, new facts emerge, then they should obviously be presented and tackled appropriately. But I wonder whether we're mixing up what the law can do with operational issues. We have, after all, as has been explained at some length from the front bench in the last debate, a monitoring committee with all sorts of bells and whistles which should be able to pick up anything which is going wrong on the ground floor. It's on the ground floor which matter. And it's that issue, operational versus the law, which concerns me. I want to quote to the House the remarks of Sir Robert Neal, who is a lawyer and chairman of the House of Commons Justice Committee, in his comments at the, I think, the third reading of the bill. He said, equally, the idea that legislation is the sole or even the principal solution to this situation is, I think, wrong. Ultimately, an operational solution is required. Ultimately, he goes on, ultimately, it will be operational measures that will make the difference. And I think this is the point. I think there's a danger here of mixing up operational issues, what may be dealt with by governments, by the Rwanda government, by the British government, by the instruments put in place by the treaty on the one hand, and getting the courts involved at too early or an inappropriate stage. I think that is the risk with the commendable idea which Lord Anderson has.
You would expect the Bishop of St Edmundsbury and Ipswich to support Lord Anderson of Ipswich, which I will do, but I want to just say a few words about Amendment 39, which has been tabled in the name of the noble Lord Blunkett, to which I added my name, and the name of my right reverend friend, the Bishop of Bristol, also was added. It simply is to ask that the right be given to those who have been who go to Rwanda and granted refugee status to, in some circumstances, to be able to return, because it may well be that Rwanda is not a country where they should remain. You can imagine issues around language, issues around the possibility of destitution, risks to victims of modern slavery, various circumstances. And the not allowing those granted refugee status to return to the UK would seem to be a failure in this bill. It's not unprecedented, indeed. The arrangements currently being made between Albania and Italy mean that those processed in Albania can, if they choose to do so, return to Italy. So I would urge that this amendment be considered as a way of making that option available.
My Lord, can I briefly just rise to say that we very much support the amendments 9 and 12 that Lord Anderson has led on, which would allow the presumption that Rwanda is a safe country to be rebutted by credible evidence presented to decision makers, including courts and tribunals. And if he were to test the opinion of the House, we'd very much support him with respect to that. Can I just refer to my own Amendment 29, which I hope gives some evidence to the need for Lord Anderson's own amendments. And that refers to Clause 4, Section 2. My Amendment 29 would take out Section 2. And the reason that I have put that is because I fail to understand why a decision maker, however that is defined, whether it's the Secretary of State, a court or a tribunal. But, my Lords, in clause 4.2, it goes on to say, to say that subsection 1 does not permit a decision maker to consider any matter, claim or complaints to the extent that it relates to the issue of whether the Republic of Rwanda will or may remove or send the person in question to another state in contravention of any of its obligations. In other words, an individual cannot put before the court or a tribunal, not that they may be refooled, but using the government's own words in subsection 2, subsection B of clause 4, will be refooled. I mean, I can just about understand it if it just had the word may, but if an individual cannot even argue that they will be, I find that quite astonishing. And therefore, I would suggest that my Amendment 29 highlights why Amendments 9 and 12 in the name of Lord Anderson are very much needed.
My Lords, I thank noble Lords for their contributions to this debate. So turning first to Amendment 39, tabled by the noble Lord Blunkett. As I set out during committee, we don't consider it necessary to make this amendment. Clause 1 sets out the obligations that the government of Rwanda has committed under the new treaty. The addition proposed by the noble Lord does not reflect the arrangements under the treaty. Enabling persons whose claims are successful in Rwanda to return to the UK would be entirely inconsistent with the terms and objectives of the treaty. Those relocated to Rwanda are not intended to be returned to the UK except in limited circumstances. And Article 9 of the treaty clearly sets out that Rwanda shall process claims for asylum in accordance with the Refugee Convention and this agreement. Since the partnership was announced, UK officials have worked closely with the government of Rwanda to ensure that individuals relocated under the agreement will be safe and that their rights will be protected. Human rights have been a key consideration throughout this work, including the treaty, to confirm the principles for the treatment of all relocated individuals in an internationally binding agreement, and strengthen monitoring mechanisms to ensure practical delivery against the obligations. For example, individuals once relocated will have freedom of movement. They will not be at risk of any risk of destitution, as they will be accommodated and supported for 5 years. They will have access to a generated integration package so they can study, undertake training and work and access healthcare. For those who are not registered as refugees, Rwanda shall consider whether the relocated individual has another humanitarian protection need. Where such a humanitarian protection need exists, Rwanda shall provide treatment consistent with that offered to those recognised as refugees and permission to remain in Rwanda. Such persons shall be afforded equivalent rights and treatment to those recognised as refugees and shall be treated in accordance with international and Rwandan laws. For those relocated individuals not recognised as refugees or granted protection, Article 10 of the treaty provides that Rwanda shall regularise their status in the form of a permanent residence permit and provide equivalent treatment as set out in Part 2 of Annex A. My Lords, it's the government of Rwanda who will be considering asylum or protection claims and who will grant refugee or protection status to those relocated to Rwanda under the treaty, which will underpin the Migration and Economic Development Partnership, not the UK government. As made clear in the agreed terms of the treaty, those relocated will not be returned to the UK except in limited specified circumstances. Obtaining refugee status in Rwanda does not grant that person any rights within the UK, as would be the case for any other person granted refugee status in Rwanda who had not been relocated from the UK. Anyone seeking entry to the UK in future would have to apply through legal routes, such as the work or family route, with no guarantee of acceptance. My Lords, Amendments 9 and 12, moved by the noble Lord Anderson, and Amendment 19, tabled by the noble Baroness Lady Chakrabarti, seek to qualify the requirement for decision makers, including courts and tribunals, to conclusively treat Rwanda as a safe country, thus allowing individuals to challenge removal decisions on the grounds that Rwanda is not a generally safe country. My Lords, the treaty, bill and evidence together demonstrate that Rwanda is safe for relocated individuals and that the government's approach is tough but fair and lawful. The government is clear that we assess Rwanda to be a safe country, and we have published detailed evidence that substantiates this assessment. This is a central feature of the bill, and many of its other provisions are designed to ensure that Parliament's conclusion on the safety of Rwanda is accepted by the domestic courts. The conclusive presumption in the bill that Rwanda is generally a safe country is not, as the Noble Lord suggested, a legal fiction. The courts have not concluded that there is a general risk to the safety of relocated individuals in Rwanda. Rather, the Supreme Court's findings were limited to perceived deficiencies in the Rwandan asylum system and the resulting risk of refoulement should any lack of capacity or expertise lead to cases being wrongly decided. As we have repeatedly set out, the treaty responds to those key findings. The assurances we have since negotiated in our legally binding treaty with Rwanda directly address these findings by making detailed provision for the treatment of relocated individuals in Rwanda, ensuring they will be offered safety and protection with no risk of refoulement. My Lords, we've been clear that the purpose of this legislation is to stop the boats, and to do that we must create a deterrent that shows that if you enter the UK illegally, you will not be able to stay. We cannot allow systematic legal challenges to continue to frustrate and delay removals. It is right, therefore, that the scope for individualised claims remains limited to prevent the merry-go-round of legal challenges and to enable us to remove from the UK individuals who have entered illegally. We cannot allow illegal entrants to be able to thwart their removal when there is a clear process for the consideration of a claim based on a risk of serious and irreversible harm. We cannot allow the kind of spurious legal challenges we have been seeing for far too long to continue. And it's for this reason that I cannot accept Amendments 23 and 27 tabled by the Noble Lady Baroness Meacher, which seek to lower the threshold for a claim or appeal brought on the grounds that Rwanda is unsafe to succeed. These amendments undermine the core principles of the bill, which is to limit challenges brought against the safety of Rwanda. The bill makes it clear that Rwanda is generally safe, and decision makers as well as courts and tribunals must treat it conclusively as such. This reflects the government's confidence in the assurances of the treaty and in Rwanda's commitment and capability to deliver against these obligations. As I've set out, the UK and government of Rwanda have agreed and begun to implement assurances and commitments to strengthen Rwanda's asylum system. So following on from my previous point with regards to relocated individuals in Rwanda being offered safety and protection with no risk of refoulement, I will now turn to Amendments 11, 14, 15 and 29, tabled by the Noble Lord, Lord Clarke. My Lords, I consider these amendments to be unnecessary. As I've just stated, yes, the Supreme Court did find deficiencies in the Rwandan asylum system that meant there was a risk that those relocated under the terms of the previous Memorandum of Understanding with Rwanda could be refooled. However, the UK and Rwanda have since worked closely together to address the Court's conclusions. My Lords, as you're aware, the Supreme Court could only consider evidence up to the summer of 2022, which was not reflective of the current evidential position. Not only could the Court not consider additional work undertaken with the government of Rwanda to build capacity in the Rwandan asylum system, but they have also not had the opportunity to consider the terms agreed under our new legally binding treaty with Rwanda. The treaty makes very clear that no one relocated to Rwanda will be returned to another country except in very limited circumstances back to the UK. This expressly addresses the Court's conclusions by eliminating the risk of refoulement. As I've said previously, and as I stated in my letter to the Noble Lord, Lord Clarke, following the debate on this matter at committee stage, the treaty contains, amongst other provisions, a definitive undertaking from the government of Rwanda that they will not remove any person relocated under the MEDP except to the UK in accordance with Article 11(1).
I'm very grateful, Minister. Can you confirm that the arrangement described in Article 10(3) of the treaty has been devised? That's the arrangement to ensure that refoulement does not in practice occur. The treaty imposes an obligation on both parties to agree a process. Has it been agreed, and can we see it?
I'm afraid I don't know the answer to that question. I will find out, however, and come back to the Noble Lord as to whether it has actually been agreed yet and where we are. There is therefore no need for this, we believe, to be considered. We're making individualised assessments as to the safety of Rwanda. My Lords, the treaty also enhances the role of the Independent Monitoring Committee, which we discussed in the last group. The Monitoring Committee will provide real-time comprehensive monitoring of the end-to-end relocation and asylum process, ensuring delivery against the terms of the agreement and in line with both countries' international obligations. This will prevent the risk of any harm to relocated individuals, including potential refoulement, before it has a chance to occur. Rwanda is one step closer to ratifying the treaty, as discussed, which has passed through their lower house in Parliament, and once ratified, the treaty will become law in Rwanda. It follows that the government of Rwanda would be required to give effect to the terms of the treaty in accordance with its domestic law, as well as in international law. Those in genuine need of safety and security will be provided with it in Rwanda. Turning to Amendment 16, tabled by the Noble Lady Baroness Lister of Bertaset, we do not accept that the individuals relocated to Rwanda would be at risk of torture or any other form of inhumane or degrading treatment. The government's assessment is that Rwanda is a safe country and respects the rule of law. Rwanda is a signatory to the United Nations Convention Against Torture, the Convention on Refugees, and other core UN human rights conventions. It has also signed the treaty with us, which guarantees the welfare of all those relocated under the partnership. The Enhanced Monitoring Committee will be in place to robustly monitor adherence to these obligations. And should somebody with a particular vulnerability be relocated to Rwanda, there will be the necessary treatment and specialist support available, with safeguarding processes in place. Furthermore, Clause 4 of this bill preserves the ability of individuals to challenge removal due to their particular individual circumstances, if there is compelling evidence that Rwanda is not a safe country for them. That is the appropriate mechanism to ensure that an individual's circumstances have been considered.
Right, but could I ask what investigations the government have made that this support is available in Rwanda? I mean, we've heard about, and this is not a criticism of Rwanda, but it's an acceptance of the facts that it is a country that has poor provision, as we have heard from the Noble Lord, Lord Scriven and others. And in terms of the individual challenge, being able to say that it's not safe for an individual, as his colleague said at committee, the government expect this to be used or be successful very rarely. So that is no safeguard, really.
Well, I was about to answer the Noble Lady's questions, because safeguarding arrangements are set out in detail in the standard operating procedure on identifying and safeguarding vulnerability, which states that at any stage in the refugee status determination and integration process, officials may, of course, encounter and should have due regard to the physical and psychological signs that can indicate a person is vulnerable. The SOP sets out the process for identifying vulnerable persons and, where appropriate, making safeguarding referrals to the relevant protection team. Screening interviews to identify vulnerabilities will be conducted by protection officers who have received the relevant training and are equipped to competently handle safeguarding referrals. The protection team may trigger follow-up assessments and/or treatment as appropriate. In addition, protection officers may support an individual to engage in the asylum process and advise relevant officials of any support needs or adjustments to enable the individual to engage with the process. Where appropriate, the protection team may refer vulnerable individuals for external support, which may include medical and/or psychosocial support or support with their accommodation, and where possible, this should be with the informed consent of the individual. My Lords, as regards capacity, of course the capacity will be in place, and the policy statement sets out, I think at paragraph 135, that in line with our obligations under the Refugee Convention, and to ensure compliance with international human rights standards, each relocated individual will have access to quality preventative and curative primary and secondary healthcare services. There are at least of the standard available to Rwandan nationals. This is provided through a comprehensive agreement between the government of Rwanda and medical insurance companies for the duration of 5 years, and through MOUs with hospitals in Kigali. Can I also say, though, at this point, that it would be far in the best interests, the mental health interests of those seeking asylum and who are victims, to seek asylum in the first safe country they came to. Why would they risk their health and mental health crossing the channel in much more grave circumstances than they need to? My Lords, Noble Lords will know that over 135,000 refugees and asylum seekers have already successfully found safety in Rwanda. International organisations, including the UNHCR, chose Rwanda to host these individuals. My Lords, we are committed to delivering this partnership. With the treaty and published evidence pack, we are satisfied that Rwanda can be deemed a safe country through this legislation. So I would ask the Noble Lord to withdraw his amendment.
May I thank all noble lords who have participated in this fast-paced debate and for the generous and constructive contributions that we've heard from all corners of this House. I shan't dwell on them individually, but may I single out the contributions we heard from the Noble Baroness Lister, Noble Baroness de Souza and Noble Lord Cashman on the subject of torture. And although my amendments are broader than theirs serve as a reminder that even evidence of widespread torture would be off limits if Clause 2 were not amended as they and I both wish. I say to Lord Murray, Noble Lord Murray, that I'm delighted by what he says he has seen in Rwanda, but with great respect to him, the points he makes in no way remove the desirability of ensuring that should protections not prove to be adequate, including, for example, protections against the risk of refoulement contrary to the terms of an agreement, which is what we saw when the Rwanda-Israel agreement was in force, then the decision makers and courts should be able to take those matters into account. That is all that these amendments contend for. To the Noble Lord Horam, I agree that it is operational measures that will make the difference. He must be right about that. Those are the sorts of measures that were identified by the International Agreements Committee in its list of 9 or 10, and indeed in Article 10.3 of the treaty, as the Noble Lord Kerr pointed out, unfinished business even when the treaty is ratified. The purpose of the courts is simply as a check that those measures meet the minimum thresholds laid down by law. The Noble Lord the Minister made the point that the concerns expressed by the Supreme Court were limited to specific issues regarding refoulement, and he suggested that those issues, if they hadn't been resolved already, would be easily resolved in the near future. I must say that the Noble Lord does ask us to take a good deal on trust. I understand that a letter has been circulated this afternoon, and certainly didn't reach me, but whether that includes, for example, full details of the Rwanda Asylum Bill, that nobody seemed to have seen when we debated this in committee, whether it contains full details of the arrangements to ensure non-refoulement that are referred to in Article 10.3 of the treaty, I cannot say. Yes.
The letter came to myself. Can I just say, in answer to his questions, the answer is no.
Well, I'm grateful, and I should say, in fairness to the Minister, that I had a letter about Northern Ireland, but it didn't touch on those issues. But I acknowledge the confidence with which the Minister defended the position on the ground in Rwanda, and I would say all the more reason then to accept these amendments. The more confident the government is in the safety of Rwanda, the less it has to fear from them. So for those reasons, I am minded to test the opinion of the House on my amendments in this group.
The question is, excuse me, the question is that Amendment 9 be agreed to. As many as are of that opinion will say content.
Content.
The contrary, not content. Not content. I'll call again. As many as that opinion will say content. Content. The contrary, not content. Not content. The question will be decided by division. I will advise the House when voting is open. Voting is now open. Clear the bar. order. The question is that Amendment 9 be agreed to. As many as of that opinion will say content. Content. The contrary not content. Not content. The contents will go to the right by the throne. The not contents to the left by the bar. question is that Amendment 9 be agreed to. There have voted contents 258, not contents 171. The contents have it. My Lords, I cannot call Amendments 10 and 11 due to preemption, and I would like to remind the House to Peers should not cross the floor in between the woolsack and the clerks during voting. Thank you. We now come to Amendment 12, and if agreed, I cannot call Amendments 13 to 16 due to preemption. Amendment 12.
The House.
The question is that Amendment 12 be agreed to. As many as the contrary not content. Not content. The question will be decided by a division. I will advise the House when voting is open. Voting is now open. Clear the bar.
The question is that Amendment 12 be agreed to. As many as are of that opinion will say content. Content. If we're not content. Not content. The contents will go to the right by the throne, the not contents to the left by the bar. Order! The question is that Amendment 12 be agreed to. My Lords, there have voted contents 260, not contents 169. So the contents have it. My Lords, I am unable to call Amendments 13, 14, 15 or 16 for reason of preemption. So I call Baroness Lawler to move Amendment 16.
My Lords. Sorry.
Amendment 17.
My Lords, I support the aims of this bill and I hope it and they will succeed, that it will not be challenged, that there will be no further obstacles put in the way of removing people who come to this country illegally and by these dangerous routes. My Amendment 17 is to Clause 2, to leave out subsection 5 and substitute the text on the marshalled list. The aim is to tighten the bill and prevent or delay the removal of an individual to Rwanda under any of the Immigration Acts, the Human Rights Act 1998, EU-derived law and case law, sections 2 to 7 of the European Union Withdrawal Act 2018, and any provision of domestic law, including common law and international law, relevant to the aim, so to limit legal challenges to the bill. I do not share the views of those who say the bill contravenes the rule of law. Their view rests on assumptions about the role of international law and its place within our own system, and the creative approach of the Strasbourg Court in applying the Convention. and on the tendency now to accord something of a primacy to courts over Parliament. These assumptions are contested within the legal profession itself. I'd like to refer to one KC, Anthony Spate, whose paper was published at the weekend by Politaire, of which I am research director, and I therefore declare a special interest in the matter. Spate explains the comparative novelty of such a view, which he dates from Lord Bingham's 2010 book, that the rule of law requires adherence to international law. But I am not a lawyer. I approach the question as a historian of British political and constitutional history. It is a history, by and large, and certainly in the era since the franchise was extended in the 19th century, of the interplay between executive and parliament, with government accountable through parliament to the will of the people, even before the extension of the franchise. At the moment, both government and parliament are intent on being accountable on this matter of curbing illegal immigration, but are prevented by laws and the judiciary which operates them, or, as in the case of the Strasbourg court, interprets them in a manner which takes from and not protects their liberty, on which good law is based, the freely expressed will of the people who are governed. On immigration, legal and illegal, the people have spoken loud and clear. They want Britain's borders controlled and the flow of immigration curbed. Parliament has passed the laws to bring such control, but each bill it brings forward meets a challenge in the courts. Is removal to Rwanda to be stopped, not by recalcitrant authoritarian monarch or an oligarchic aristocratic landowning parliament, as in the past, but by a judiciary acting, I do not doubt, in good faith, to give effect to a cocktail of legislation binding this country from an era whose laws are not our own and from times that are not our own. There are practical limits to what a government, good government, can achieve. It is recognized perhaps more clearly by voters than by rulers that uncontrolled immigration, facilitated by the obstacles now put by the courts, often, as in the case of illegal immigration, through asylum claims, has consequences for the economy in terms of the budgetary costs and puts demands which can't be satisfied on Britain's domestic arrangements, not just for processing claims, but every manner of support which the UK's people have, over the centuries, shown to those who, for whatever reason, come to make their lives in this country. If our Constitution is to survive the onslaught of legal challenge, the will of Parliament, reflecting the mandate of the voters, must triumph, and with it the stability, transparency and accountability which has brought to Britain and its people, rather than be challenged on account of international or our own laws. This country is no outlier, my lords. Across the Channel, the political systems of Western European neighbours are buckling under the political immediacy of uncontrolled immigration, each seeking to exploit or avoid the system to which in law they are bound under EU law, convention law, and the mass of internal legislation to which these have given rise. They also have Schengen to take account of. Take the case of France. Its political system was practically frozen for 2 years, haggling over an immigration bill, which many see as promising too little, too late. The problem with which it too grapples are immense, the constitutional arrangements and stability under threat at different levels, departments pitted against national powers, as in the recent standoff between some mayors who refuse to accept unaccompanied minors because they have no ability to do so and look after them. At government level, against the ruling of the Strasbourg Court, its voters against the traditional systems of the political parties, the Republicans and the Socialists. We in this country are free to make our own laws. And other noble lords in this group will speak on their amendments to this, the amendments they intend to move on the same theme. My amendment aims to tighten the bill, to preempt further challenge, which, as the Minister mentioned earlier, is a core principle and aim of this bill, to prevent further challenge, and to the workings of ordered and representative and accountable democracy, and to promote the aims of the bill to delay illegal and unsafe crossings and deter the horrid loss of life, such as the death of a little girl of 7 in the Channel on Sunday night in freezing waters. I therefore beg to move.
Amendment proposed, page 3, line 13. In place of the words last left out, insert the words as printed on the marshalled list. Amendment 17.
My Lord, I rise to speak also in favour of Amendment 17, tabled by my noble friend Baroness Lawler, to which I've added my name. As I said at second reading, I do support the bill. I am a bit afraid the Rwanda policy is a bit of a Heath Robinson arrangement and does shy away from some of the tough decisions really needed to solve the problems. But still, I support the bill because it's the plan we have, and we must hope it makes a difference. But it can certainly be improved. Now, most of the amendments we've discussed today would make it worse rather than better, less effective rather than more effective. Amendment 17 is one of the few exceptions to that, and it aims to provide a more clearly drawn bill, one that can withstand challenges and fulfil its purpose more effectively by making clear that no other legal provisions of any kind, whether in domestic or international law, can be used to frustrate the policy. Now, my Lords, I don't want to repeat issues that have already been raised in committee and discussed again at length today, but I do want to briefly explain why I support this amendment and then to make one comment at the end based on my own involvement in recent years on this issue of the intersection between international and domestic law. So, first of all, it's in my view absolutely clear that this Parliament may legislate against international law, and indeed the government may act in contravention of international law. As we've already heard, Clause 1, Paragraph 4 makes that clear, and nobody is seeking to amend that. It is a long-standing fundamental element of our Constitution. Now, it's not some sort of weird UK-specific provision. There's a good reason for this dualism in our system. First of all, is that otherwise governments could act to create domestic law merely by signing an international treaty and thereby sidestep normal democratic processes. Second, it reflects the reality that international treaties are in practice very difficult to adapt to changing conditions because all the parties must agree to changes. Now, it's been suggested by some noble lords today and in previous debates that that's what should happen, that we should seek to renegotiate the international framework. Now, the Refugee Convention, for example, has got 149 state parties at the moment, including such well-known supporters of international law as China, Russia and Iran. Are we going to wait for all of them to agree to amend this framework? Now, we're clearly not, but if national governments accept they can only act, they can only deal with pressing national challenges by renegotiating these treaties, then they're effectively abandoning their duty to govern their own countries on matters of huge importance. Now, if a government chooses to act against international law, it may pay a reputational price for it, a price that, as we've heard in the case of France, is often hugely exaggerated. It may consider that price justified, depending on the circumstances, but it must weigh up that price. Now, that's what the government's done in this case. I do worry it set the balance in the wrong place. It set supposed compliance with international obligations crafted in a different era. It set that onto a higher plane than the core state function, one of the basic raison d'etre of a government, which is to control the country's borders. And that's where Amendment 17 is designed to help. It's designed to deliver the goods which are invoiced, as it were, in Clause 1, Paragraph 4. That clause recognises there is a right for governments to act, and Amendment 17, if it were to be agreed to, which I suspect it isn't going to be, but if it were to be agreed to, it would be the necessary action. It does what's necessary to make this policy work by closing off, as far as possible, the ability to challenge it and the ability of domestic or foreign courts to act against it. And it does that with the goal of delivering what people in this country want, a government that's actually in control of our borders. Now, just briefly to finish my second point in my comment, I know this is the third time Parliament has debated this issue of compliance with international law, and I've had some small hand in two of the previous occasions. The UK Internal Market Bill, now Act, where the relevant clauses that would have explicitly breached international law were withdrawn. Then the Northern Ireland Protocol Bill, where the whole bill has been withdrawn. And now we have the Rwanda policy. Now, it's not a coincidence that this keeps coming up. The UK is enmeshed in a set of international legal obligations, which in defiance of our constitutional traditions are in practice constraining the sovereignty of this Parliament, and therefore the ability of any government to act in the interests of the good governments of this country. Now, while we were in the EU, the huge constraints that all this imposed, membership of the EU imposed, made those other legal obligations less visible, though no less intrusive. Now, we're not in the EU, they're there for everybody to see. So, mark my words, I'm afraid, this issue is not going to go away. I don't think the government's quite faced up to it with this bill. It in particular hasn't faced up to what I think is the need to free ourselves from the ECHR. And I think the only issue is how much more time is going to be wasted, how many more constitutional traditions are we going to lose, how much more is democracy going to be circumscribed before government does what's really necessary in making the top priority the democratic wishes of our citizens and the good governance of this country. And that's why I support to complete Amendment 17. It at least shows the necessary direction of travel, and it signals very clearly what, in my view, is in the end going to be necessary to fix this problem.
My Lords, just very briefly, I wanted to support Amendment 17 in the name of Baroness Lawler, and to just say a few words about the Northern Ireland perspective on this, because we've had this discussed at various stages about whether this is really going to apply to Northern Ireland and the effects if it doesn't. Now, in the amendment itself, of course, even in the Safeguarding the Union Command paper, there are a number of things that have already been exposed as not actually correct. And on the amendment, I would have actually liked more specific language in subsection 5C, so that there could be actually specific mention when we talk about international international law, to actually mention section 7A of the European Union Withdrawal Act. Because I think sooner or later, and I think the Noble Lord Frost is absolutely right, this is not going to go away, and sooner or later we're going to have a legal challenge, probably first in Northern Ireland, on Section 7A and how this is, whether this applies. Because we saw last week the effect of the protocol framework is to give EU law supremacy in Northern Ireland, even to the point whereby the Act of Parliament that was passed, whether you agreed with it or not, the legacy bill, could be struck down due to inconsistency with EU law applying because of the protocol. And I think the government and the minister does need to actually clarify, because there is a lot of confusion and a lot of, let's say, being gentle, misleading about how Article 2 actually works. Now, Lord Kane, the Noble Lord Kane, in written answer to me on the Rwanda Bill, claimed that the EU Charter of Fundamental Rights did not apply to Northern Ireland via Article 2 of the Protocol Framework. And this is actually at variance directly with the High Court judgment in Angesom, and also, of course, the last week's High Court in Northern Ireland disapplying 10 provisions of the Legacy Act. So the government can't really keep making claims that are so obviously not true, and then get really angry almost when we point out things legally as to how it's working. So I think this is another example of the degree by which control over part of the United Kingdom has been really genuinely surrendered by this government while pretending that it's not happening. Let's not forget that the Windsor Framework, it's very specific. Page 19, paragraph 46, that the Windsor Framework only applied in respect of trade, and that Article 2 did not apply to immigration issues. I think we're going to find that that is not correct. So on this issue of the Rwanda Bill and the effect of Article 2 of the Protocol Framework, the proponents of the deal really need to be clear. It doesn't apply in this bill in the same way in Northern Ireland because of Article 2 prevents it doing so. The EU Charter of Fundamental Rights continues in Northern Ireland, and I think we should be honest about that. And the Protocol Framework provision trumps domestic law and trumps the wishes of our sovereign Parliament. And I think noble lords should be aware that we are going to find that whatever your views on this Rwanda Bill are, that ultimately this is going to end up in another legal challenge which will, whether the bill has gone through or not, will delay its implementation. So I do support the amendment, even if it didn't specifically mention the withdrawal agreement.
I'd like to speak to Amendment 18, to Amendment 20, which I share with the Noble Viscount Hailsham, with the Noble and Learned Lady Baroness Hale of Richmond, and the Lord Archbishop of St Edmundsbury and Ipswich. And I also support the Starred Amendment 21 in the name of Lord Jermyn. Amendments 20 and 21 both restore Human Rights Act protection in full for those subject to this bill and pending removal to Rwanda. I think that the Noble Lord Jermyn's amendment does it in even clearer language by not referring internally to last year's bus or last year's immigration bill, but clearly stating for the lay reader that Human Rights Act protection is restored. The Amendment 18 is, however, a revision of the amendment tabled last time at committee by the Noble Lord Clarke. It's a modest revision in order to address some of the concerns made by some of his noble friends. He's not able to be here this evening. And I begin with that one because it really is so mild and so in keeping with the thrust of the bill and cannot be described as wrecking or disturbing the framework, even of a bill I object to, in any way. All it would do, Noble Lords will know that in clause 3 of the bill, most Human Rights Act protection is removed for these vulnerable people. But the one thing that is left is the possibility of a declaration of incompatibility. And contrary, I fear, to some of the comments made by the Noble Lord Clarke of Nottingham and others, there is no possibility in our arrangements for a strike down by the Supreme Court of this bill were it to become an act, because that is not the arrangement that we have in the elegant British constitutional compromise of the Human Rights Act and the balance it strikes between the rule of law, that is the bedrock of any democracy, and parliamentary sovereignty. So if an act is declared incompatible, That declaration has merely moral and persuasive effect, and the Act continues in operation. That's why, with the greatest of respect to him, the noble Lord Clarke was optimistic to the point of being wrong about that. And so what the noble Lord Clarke came up with last time was just a suggestion that if there were to be a declaration of incompatibility made by our higher courts in relation to this legislation, there should be accelerated consideration in Parliament. That's it. And I'm pretty flabbergasted with the government's response that they wouldn't even have a look at that most modest amendment by their noble friend, a former immigration minister, Lord Clarke of Harrogate. And so in his absence, I've retabled it. It's been tweaked slightly to address some of the points made by his noble friends last time. And I really do look forward to hearing what the objection is to that modest suggestion that he made, that if there is a declaration, Parliament should have an accelerated timetable, and ministers should put their arguments to Parliament, not to a court, but to Parliament, and Parliament be given the opportunity to consider what to do next. As for our amendments to restore Human Rights Act protection and restore, again, it's another way of trying to restore the protection of the domestic courts. I just say to the government, and here actually Lord Frost has a point, where the government have left us with this bill is probably, if it passes unamended, we will be in a situation where the only court that will really be seized of these matters, the only court that will be able to have full jurisdiction over the safety of Rwanda and over individual removals from this country to that country, will be the European Court of Human Rights. Of course, interim measures will be ignorable by a Minister of State, but final orders of the European Court will still be an international legal law obligation, and that has not been removed by this bill. Therefore, Lord Frost is actually the one who's telling the truth about the logic of where this government is heading. And that is really for walking out of the Court of Human Rights, walking out of the Council of Europe. We can follow Russia and be the next ones out. At least he is honest about that position, whereas the government is trying to have it both ways. And what they've done is they've defenestrated domestic courts, gaslit the Supreme Court, but the only court that will be left for redress in any real terms will be the Strasbourg Court. And then, of course, the Prime Minister can say, I told you what I said about foreign courts, because foreign courts will be all that is left if that is what we now say about international courts. Goodness me, what terrible, terrible politics. And finally, I say to the noble Lord Frost, who's sort of had enough of international law, really, because, you know, that's kind of where he's coming from. The challenges facing not just the United Kingdom, but the world today, the most pressing challenges, whether climate change, war and peace, the challenge of the ungoverned continent that is the internet, AI, robotics. How on earth are we going to address these challenges of the 21st century in a unilateral way? It is just nonsense. And to the noble Lady Lawler, who doesn't seem to like law, whether it's domestic or international, I hope she never has need of it. I hope that she is never subject to the kind of abuse of power that sometimes people are subject to, and they need the protection of the courts.
Sits down. May I ask her to be clear about what I proposed and to what I was referring. I was referring to the laws of this country made by the people of this country with the support of the people of this country. Good laws. Yes, they support international treaty law when that is in the interests of this country and other wider interests which arise, whether it's trade treaties or international agreements over other matters. But it is wrong to suggest I am not in favour of law. I am in favour of good law, but not politicised law, as it very often is by the interpretations of the Strasbourg Court, of the Convention?
Well, I'm grateful. I'm very grateful to the noble lady for her clarification. Though, of course, as I pointed out, and I think Lord Frost was nodding, the Strasbourg Court is unaffected in its final jurisdiction by this bill. It is our domestic courts who are defenestrated by this government policy. And I just look to her amendment, which is actually abrogating domestic laws, any provision by the Immigration Act, the Human Rights Act, another domestic statute, any other provision or rule of domestic law, including any common law, in case Magna Carta still got a shout out there, and of course international law. So she's been pretty comprehensive in her approach to law in this amendment, whether domestic or international. Of course, she says, but these are just it's only bad law that I don't like. But of course, we all have our own views, don't we, about good and bad law. But some of us believe that there should be referees in a democracy that is built on the rule of law. And the rule of law was invoked, as I said earlier, by the Prime Minister, even in his slightly odd Downing Street declaration on Friday.
He sits down. May I clarify that my amendment is designed to promote the aims of this bill, to remove people who come to this country illegally to Rwanda and to stop obstructions on this matter.
My Lords, could I add a very, very few words to this debate on the Human Rights Act? And I would like to point out that this is the first time that I've actually spoken in this group. This amendment seeks to return the responsibility of interpreting the law to the courts, and specifically underlines the unacceptability of a law on the statute book which is incompatible with domestic law, which of course includes the UK Human Rights Act. And unless and until the courts affirm that the Act conforms with the strictures of the Human Rights Act, it must not have any effect. To do otherwise, my Lords, would be to reject the rule of law, which is one of the pillars of the UK Constitution.
I just want to speak a couple of brief points in support, in particular, of Amendments 20 and 21. First, in committee, the noble and learned Lord, the Minister, Lord Stewart, quoted at length the Lord Chancellor's submission to the Joint Committee for Human Rights to justify breaching the universality of human rights. Now, clearly, the Lord Chancellor didn't convince the Joint Committee on Human Rights, which in its majority report concluded that the provision threatens the fundamental principle that human rights are universal and should be protected for everyone. So why, I still don't understand, given the concerns expressed by the JCHR and also by, for example, the EHRC, the Law Society, the Northern Ireland Human Rights Commission, does this government continue to try to argue that disapplication does not affect the principle of universality, which in fact the noble learned Lord waxed lyrical about in his speech? Second, the noble and learned Lord promised to write to me in response to my concerns about the implications for the Windsor Framework and the Good Friday Agreement, and following on from the noble Baroness Lady Hoey, and the Joint Committee for Human Rights request for a full explanation before report stage as to why the government considers Clause 3 is consistent with these agreements. Well, I thank the noble and learned Lord for his letter, but echoing what the noble Lord German said earlier, I would gently point out that it was sent at 3:24 this afternoon after report stage began. That really is not good practice. And it does not meet the JCHR's request that the explanation, a full explanation, should be published before report stage. And it seems that the actual full sort of publication won't be until sometime by Wednesday, when we'll be finishing report stage. Now, I'm not convinced about the answers to my question that they would satisfy the JCHR, the Northern Ireland Human Rights Commission, or the Human Rights Consortium of Northern Ireland. And I'm also not clear why the letter wasn't copied to the Noble Baroness Lady alone, given that she originally challenged the Noble Lord the Minister on this point at second reading. But I'm not going to kind of pursue the matter here, but it's just really to point out that I don't think we yet have a satisfactory explanation as to the interaction with these agreements, implications for these agreements.
My Lords, I'd like to speak to Amendment 21, which is my name, and also to link that with the Amendment 20 and 18. If Amendment 20 had had any space, I would have signed it as well, because it makes the same case. I will address the Amendment 17 later, and I'm looking forward very much to seeing how the government deals with Amendment 17 in its response. But at the moment, just to repeat what the universality issue of human rights. It is human rights are for all. I read once again Lord Stewart's, Stilton's, the Noble Learned Lord's response about legitimacy, and I'm sure we'll hear it again today. But there's still the underpinning of the Human Rights Act is that the protections should not be disapplied just to some people. Because if human rights are for all, then if they become qualified, then they are no longer human rights, but only the rights for some people. And this violates the principle of universality of human rights, which is why this amendment is in place. It doesn't matter that this is directed at illegal migrants. Once the government does this for one group, it will choose to use it, or could choose to use it, from other groups, such as protesters. Yes, a protester.
So is the logic of the Noble Lord's point, therefore, that the government would be better to repeal the Human Rights Act completely and revert to the pre-1998 situation?
Simply keep the Human Rights Act, and of course that does do the job that we are we are seeking here. But naturally, of course, if the government wants to move and create a special group, as it is here, what they call illegal migrants, then what about the other groups who might follow from it? Protesters it is very clear that that may well be an issue. What groups which are not in vogue with the government? It's a very, very dangerous precedent, and this is a warning sign. Fundamentally, what I think we're seeing here is chasing short-term headlines which will have a significant consequence for people's rights in this country. But, my Lords, not content with arguments the government is having with the views of the ECHR and the UNHCR, the government, just this week, in the last 7 days, has now drawn swords with the United Nations, its Council for Human Rights. Published last Friday, this is what they said: prohibiting courts and tribunals in the UK from applying and interpreting principles of domestic human rights law and international law would undermine the ability of the courts to protect all those under UK jurisdiction from violations of their human rights as provided under international law. And they go on further to say that the government should look at this matter again, and the United Nations have offered to speak and to work with the UK government on this matter. So I wonder if the Noble Lord, when responding, could tell us whether or not they have read the United Nations Human Rights Council's review, and whether they are prepared to meet with them and to discuss this matter further. But there is also a logical inconsistency, I think, here in what the government's doing. The government can't have it both ways. It wants to rely on the International Convention and jurisprudence in justifying the disapplication of the Human Rights Act, but it's then seeking to disapply the findings of that same court in relation to the same international convention with respect to the consideration of interim orders. So you can't have it both ways, and I think the government needs to be clear on that matter. I just want to make, I think all the comments that the Noble Baroness Chakrabarty has made about Amendment 17 are absolutely accurate. But there is one thing that worries me completely, and that is the part of the amendment which just basically takes away every law that this country might apply in this direction, domestic law and common law of all, for goodness sake, common law as interpreted by the courts. Can you, I don't know how you find which parts of common law you want to disapply. You have to be specific in what you say if you want to disapply anything of this nature. But basically, what that Amendment 17 looks to me like is a complete wiping out, blanking out, blindfolding every single possible piece of legislation which might stand in the way of this government's view. And that certainly, but absolutely, must affect the balance which we talk about the rule of law in this country. So I look forward to seeing how the government will deal with that amendment, but I would suggest that they might need to consider how they actually move forward and no further discipline application of the Human Rights Act.
My Lords, I'm going to speak quite briefly. These amendments again in this group again demonstrate the threat to the domestic rule of law posed by this bill. This isn't the first bill that threatens the Human Rights Act in this way, but the fact that it now seems almost commonplace for the government to strip back human rights legislation, it does not mean that it should go without objection each and every time. There is much to object to in this bill, and Clause 4 is no exception to that. Each cut to the Human Rights Act matters, and each piece of domestic law that is cut away in search of a quick political gain matters as well. And I hope the government listened to these arguments, the arguments put forward by my noble friends, and see sense. But my Lords, I have to say I found this debate, although relatively brief, actually quite refreshing as well, because, I mean, Lord Frost was perfectly candid with the House, and it was for a layman, it was much easier to understand the political differences between the view articulated by the noble Lord and the view on the other side of the House, and it was much easier to understand that difference than when I try and decipher the words of the ministers when they respond to these amendments. But nevertheless, I look forward to what the noble Lord the Minister has to say.
My Lords, the noble Lord Lord Ponsonby has flung down the gauntlet. On behalf of His Majesty's Government, I'm happy to pick it up. My Lords, I'm grateful to all who participated in this debate, and I do sincerely echo the words of the noble Lord when he said that it was a refreshing quality to this short debate. I think that the House articulated some important points, and contrasting positions were well properly and clearly laid out for consideration of the House. My noble friend Baroness Lola opened with the support of my noble friend Lord Frost. And I begin by saying, as I've said at an earlier stage in this debate, or rather in the handling of this bill, that it is important to recognise, as my noble friend did, that the levels of illegal migration to this country, perhaps to the whole of Western Europe and other comparatively prosperous parts of the world, are placing enormous strain, not only on us economically, but also straining the fabric of society and straining perhaps also public confidence in the ability of our courts and our democratic legislatures to address problems. I'm grateful to both my noble friends for their broad support for the aims and objectives of the bill. My Lords, I think that Lord Frost put it clearly and accurately in constitutional terms when he repeated that this Parliament may legislate in contravention of international law. It is a long-standing element of our Constitution, and the Noble Lord also, I think, accurately and correctly identified that the price of any such, the high price to be paid for any such step, is a matter of reputation. That such reputations of countries as of people may be very easily lost. I echo again what the Noble Lord had to say about the way in which it is difficult to adapt international treaties drawn up in different times and in different circumstances. There was an intervention as he was speaking with the Noble Lady Baroness Chakrabarti, and I think that from the perspective that I took on it, it seemed to me that my noble friend Lord Frost wasn't saying that he'd had enough of international law, but rather that he wished law to operate in its proper context. The Noble Lady Baroness Hoey made if I may say, an extremely important contribution on what is a very important point, and the Noble Lady Baroness Lister of Burterset also touched upon that, and it's the status of law of the United Kingdom in one of its constituent parts as opposed to other constituent parts. My Lords, the government is considering the judgment in the case to which the Noble Lady referred, that of Dillon, in relation to Article 2 of the Windsor Framework, and all the available options, including appeal against that decision, very carefully. Our position is this, that the bill will apply in full in Northern Ireland, and the government is clear that nothing in the Windsor Framework, including Article 2, or the Trade and Cooperation Agreement, affects the bill's proper operation on a UK-wide basis, a matter very important to this government. The government has always been consistent about the position of Article 2 of the Windsor Framework. For Article 2 to be engaged, it would be necessary to provide evidence that the alleged diminution of rights relates to a right set out in the relevant rights, safeguards and equality of opportunity chapter of the Belfast Good Friday Agreement, concerns a right that was given effect in domestic law in Northern Ireland on or before the 31st of December 2020, and occurred as a result of the United Kingdom's withdrawal from the European Union. Nothing, my Lords, in the bill, which is about matters of asylum and immigration, engages any of these issues. As such, it would be incorrect to claim that its provisions are within the scope of Article 2 of the Windsor Framework. The Noble Lady Baroness Lister of Burterset, in taking up the points, also, I think, perhaps referred to an important matter, which is the speed of communication with letters being written after the earlier stage. I see the Noble Lord Cashman nodding his head. I do apologise to the Noble Lady and to others in the House who are recipients of letters. I signed the terms of the letter off, however inadequate the Noble Lady may have found it ultimately, but I signed the terms of the letters off on Saturday afternoon. My Lords, if I may continue to take your Lordships through the Government's position in relation to the amendment tabled by my noble friend Baroness Lola with the support of the noble Lord Frost. This amendment limits legal challenges. It may be, of one view, seen as undermining the safeguards that are necessary to ensure that this bill and the Illegal Migration Act are compatible with the United Kingdom's international obligations. The Illegal Migration Act and this bill include provision for a person subject to removal to a safe third country to make a limited class of suspensive claim on the ground that they would face a real risk of serious and irreversible harm if they were removed. The threshold for serious and irreversible harm is a high one, and the harm in question must be both imminent and permanent. And my Lords, this reflects the test applied by the European Court of Human Rights. This legislation provides that a court may grant interim relief only, which prevents removal to Rwanda, where it is satisfied that a real, imminent and foreseeable risk of serious and irreversible harm is in existence. These measures, my Lords, are necessary to ensure compatibility with the European Convention on Human Rights and ensure that the grounds by which people can challenge removal are appropriately narrow. As has been set out by me and by my noble friend Lord Sharp of Epsom from the dispatch box, and in relation to other amendments, I'll come back to this, the bill reduces unnecessary challenges whilst preserving the principle of access to the courts, where an individual may be at a real risk of serious and irreversible harm. As a whole, the limited availability of domestic remedies maintains the constitutional balance between Parliament's authority and the powers of our courts to hold the government to account. My Lords, this country has a strong track record of rights, liberties, protection of human rights internationally, and we are committed to enhancing that record. Some of the provisions in this bill are novel, though they are not without precedent. Noble Lords will also know that Australia has undertaken a similar approach with Nauru. And we know, my Lords, that other countries are exploring similar models. For example, Italy, which has announced a partnership with Albania. The government, my Lords, is satisfied that the bill can be implemented in line with the Convention rights, and I would ask the noble Baroness to withdraw her amendments. My Lords, the theme of these provisions, the theme of the bill, is very much one, and I echo again the words of my noble friend Lord Howard of Lympney, no longer in his place. It is one of accountability, and it addresses, I think, the concerns that my noble friends from this side advanced to the House, that the effect of illegal migration on the scale with which we are currently experiencing it, and notwithstanding the successes which we have recorded and which I spoke about in an earlier group, are straining not only our ability to fund the phenomenon of illegal migration, but are straining the ability of the electorate to have faith not only in the courts, but in this place. My Lords, in removing Clause 3 entirely, as well as disapplying Section 1.5 of the Illegal Migration Act, as Amendments 20 and 21 seek to do, that would mean that the Human Rights Act applies in full to this legislation, as well as the Illegal Migration Act, in relation to removals to Rwanda. This would increase the risk that a person challenging their individual removal would frustrate the entire scheme by bringing systemic challenges on human rights grounds. It would also increase the risk of litigation, asking the courts to interpret the bill in such a way as to be inconsistent with the clear intent of Parliament, undermining Parliament's conclusion on the safety of Rwanda being accepted by the domestic courts. Section 3 of the Human Rights Act requires courts to interpret the meaning of legislation to make it compatible with Convention rights so far as it is possible to do. Disapplying Section 3 confirms and ensures that the provisions will be interpreted in accordance with the usual principles of interpretation, primarily by applying the ordinary meaning of the provisions. It follows the approach taken in the Illegal Migration Act, which the amendment by the noble Lady Baroness Chakrabarti also seeks to disapply. Disapplying Section 2 of the Human Rights Act ensures that considerations about the Rwanda Treaty and the safety of Rwanda are firmly located with Parliament, providing that element of accountability which my noble friend Lord Howard of Lympney called for so eloquently. Taken together with the rest of Clause 3 and the bill as a whole, this provision makes clear that appropriate deference should be given to Parliament's sovereign and final determination in the matter. Clause 3 also applies, disapplies sections 6 to 9 of the Human Rights Act from decisions, whether by decision makers or the courts, related to the conclusive presumption that Rwanda is safe and any application of the serious and irreversible harm test. Disapplying Section 6 confirms that public authorities are not bound in domestic law to act in a particular way as a consequence of Convention rights. In the context of this bill, which deems Rwanda a safe country, this is targeted at preventing people from frustrating removal by bringing systemic challenges in our domestic courts. The disapplication of Sections 7 to 9 of the Human Rights Act follows from the disapplication of Section 6. These are the operative provisions of the Human Rights Act that flow from Section 6, providing for judicial processes and remedies. Given that Section 6 is disapplied, these provisions are not needed. Turning to Amendment 47, tabled by the Noble Baroness Lady de Souza, and Amendment 18, tabled by the Noble Baroness Lady Chakrabarti, these amendments are designed to expand the current process under Section 4 of the Human Rights Act and to place pressure on the government to present legislative proposals to Parliament. In so doing, they seek to oblige the government to respond to declarations of incompatibility in a certain way. And that, my lords, is expressly what I'll give way to the noble lady.
I think a closer reading of the Amendment 18 will demonstrate that it's not ensuring that the government responds in a certain way. It can respond favourably or negatively to the declaration. It just needs to come to Parliament and have the debate.
In her address today, and I think at an earlier stage, has described the functioning of declarations of incompatibility in Section 4 of the Human Rights Act 1998 as an elegant compromise. It is an elegant, I freely agree, constitutional compromise which ultimately reflects that parliamentary sovereignty which lies at the very heart of our processes and our constitution. As detailed during the committee stage, Section 4 of the Human Rights Act, in relation to the system of declarations of incompatibility, is designed to strike that compromise appropriately between scrutiny of human rights and parliamentary sovereignty. Section 4 does not oblige the government to take any specific action as a result of a declaration of incompatibility, and Section 4.6 expressly does not allow a judicial ruling to prevent the operation and enforcement of legislation passed by Parliament. The operation of the section is to afford the government the opportunity to reflect on matters, to listen to concerns brought by the courts, and to act upon them as it sees fit. I do not consider it necessary to adopt the amendment which the noble lady has tabled and argued for, but I do so purely on this basis that the history of the application of this section, in my view, respectfully shows it to be working. The noble lady Baroness de Souza tables Amendment 47, seeking to undermine Section 4.6 of the Act by providing that a declaration of incompatibility results automatically in the legislation ceasing to have effect. It seeks to give such declarations a binding character, and that, as I was saying a moment ago in relation to the noble lady's point, is contrary to what those provisions were designed to be, and removes discretion or oversight, as is currently afforded government and Parliament, as to what action would be the most appropriate to take in the circumstances. It has been the accepted practice since the introduction of the Human Rights Act for the government to address such declarations either through primary legislation or by way of a remedial order. And again, my lords, given how well the declaration of incompatibility procedure is working and has worked in the past, I respectfully submit that there is no reason for us to innovate on that basis. These amendments are therefore not necessary. They are also, I submit, inappropriate in that they attempt to legislate for parliamentary procedure in this matter. The declaration of incompatibility procedure works well to strike the right balance, and there is no reason to upset it. My lords, I was addressed on the subject of the remarks made by the Lord Chancellor to the Joint Committee on Human Rights, and as your lordships have said, and indeed it was predicted that I would refer to this again, and I will, but the Lord Chancellor recently set out in his letter to the Joint Committee that while it is a fundamental tenet of modern human rights that they are universal and indivisible, it is legitimate to treat people differently. A citizen may be legitimately treated differently and have different legal rights from a non-national, recognising that there is a difference between a citizen and a non-national. And the Convention as interpreted by the case law of the European Court of Human Rights, recognises this principle in full. There is nothing in this bill that deprives any person of any of their human rights. In accordance with Article 1 of the Convention, we shall continue to secure to everyone within our jurisdiction the rights and freedoms defined in the Convention. What we can do legitimately, and what we are doing, is to draw legal distinctions between those with a legitimate right to be in this country and those who have come to this country illegitimately. My Lords, as I say, the provisions in the bill, while novel, are not without precedent, and we are satisfied that the bill can be implemented in line with the Convention rights. I would therefore ask noble Lords to withdraw their amendments.
I'd like to thank my noble friend, the Minister. I'm very grateful to him for his courteous and thoughtful reply on my amendment. I'd also like to thank all noble Lords who spoke in this debate. We've had a very refreshing, as others have commented, debate, and it's been very spirited too. We all share a commitment to the rule of law and a respect for the rule of law, but we differ over the interpretation we give to that and the weight we give to the different parts of our constitutional powers, government, the judiciary and Parliament. I'd like to thank especially my noble friend Lord Frost for reflecting on the continuing tension between laws made in this Parliament on the express wish of the people of this country which command popular support, and laws made elsewhere, very often originating from different times to apply to different circumstances. I understand, though, my noble friend is keen to reject this amendment, but I hope that he will reflect further on one of the aims of this measure to prevent legal challenge to removing people who come to this country illegally to Rwanda, and also to ensure that we do indeed operate a deterrence to stop the ghastly tragedies we see too often in the Channel.
Is the noble lady seeking to withdraw the amendment?
Yes.
Your Lordship's pleasure that the amendment be withdrawn. Amendment by leave withdrawn. Amendment 18, Baroness Chakrabarty, not moved. Amendment 19, Baroness Chakrabarty, not moved. Amendment 20, Baroness Chakrabarty, not moved. Amendment 21, Lord German, not moved. Amendment 22, Lord Everton.
So I rise to move this amendment and related amendments which I have tabled 24, 26, 28 and 30. I'm extremely grateful to those who have co-signed all or some of these amendments, in particular Noble Lord Cashman, the Noble Baroness Lady Butler Sloss and the Noble Baroness Lady Bainton. I shall speak very briefly about this because I've spoken previously about it both on second reading and on committee. The current version of Clause 4 enables an applicant to oppose removal to Rwanda on the ground it's not a safe country for the applicant, but only if the applicant provides, I quote, compelling evidence relating specifically to the person's particular individual circumstances. That's end quote. Similarly, Clause 4.4, which relates to the ability to obtain interim relief for removal to Rwanda, depends on particular individual circumstances relating to the applicant in question. Now, the defect in these provisions, which is a very basic defect, is that no provision is currently made for those applicants who come within one of the important categories of refugee defined in Article 1A2 of the 1951 Refugee Convention. Now, that category comprises those applicants who have a well-founded fear of persecution because of their membership of a particular social group. Now you can immediately see the difference between other categories of applicant under the of refugee under the Convention, who are individual persons, and this category, which is probably the largest category, or certainly the most important category, which comprises a large number of people who fall with and qualify as a refugee because they are members of a social group. And yet when we look at Clause 4, and I mentioned Clause 4.1 and Clause 4.4, dealing with interim relief, there is no reference whatsoever to group. So one particular category of refugee has simply dropped off the list completely. Now, the proper approach of courts and tribunals to such a refugee was described in detail by the Supreme Court in H.J. Iran against the Secretary of State for the Home Department, and H.T. Cameroon, again against the Secretary of State for the Home Department, the 2010 decision of the Supreme Court, especially in the judgment of Lord Roger of Earlsfree. I'm not going to take the House through the case in detail. It's sufficient if I briefly say that the approach to be taken, as established by that case, is that if the applicant for asylum claims to be part of or a member of a particular social group, the other members of which have a well-founded fear of persecution, then the applicant is entitled to be considered a refugee provided that they satisfy the particular decision maker that they are a member of that social group. Now, this H.J. Iran and the other case I mentioned concerned men who wanted to live an openly gay life, but would have faced persecution in their home country had they done so. But the principle of that I just described, of the way to treat this particular category of refugee set out in H.J. Iran, applies across the board. It's not limited to people who are LGBT. It applies to those who are members of a particular social group because of maybe ethnicity or gender or religion, who hold a particular religious or a particular political belief. So, for example, by way of analogy with those who did apply, the LGBT men who did apply in H.J. Iran, if people hold particular philosophical or political or religious views which they have not expressed because of a real risk of persecution, but would like to do so and want to live a life where they can express those views, then they are to be treated as members of a social group and to be granted the status of a refugee accordingly. And as the noble Baroness Lady Chakrabarti said at committee, the bill presents us with a false dichotomy. On the one hand, it's all about me, the claimant, the individual, and on the other hand, about Rwanda generally. The former, the bill says in Clause 4, allows you to make a claim for interim relief or removal generally to Rwanda, but the latter does not. But in between those two extremes, there is the category of a group, a member of a social group with a well-founded fear of persecution. This is not a torpedo point. This is not intended in any way to undermine or delay this particular legislation. But it is a reflection of the omission of a basic category of refugee defined in the Convention, and an extremely important category as well. On that basis, I beg leave to move.
My Lords. Clause 4, page 4, line 12, insert the words on the marshalled list.
The Chair. My Lords, I put my name to the 4 amendments of the noble and learned Lord Etherton, and I support everything he says, and since we're at report, I don't propose to add to it. But what I also have is an amendment of my own at Amendment 42, and I declare an interest as the co-chairman of a parliamentary group on modern slavery and the deputy chair of the Human Trafficking Foundation. And I spoke to this at committee, and quite simply, taking on what the noble and learned Lord has just said, this is a very special group of people who are in this country not because they have chosen to take the boat trip, but because they have been brought here either by boat or by lorry or by some other route, and they are victims. So when one starts complaining about people who should have stopped in France because France is a safe country, it absolutely does not apply to victims of modern slavery. They are here on an involuntary basis, and they need to be regarded in a totally different way. I've heard endlessly, since I've been opposing much of the Rwanda Bill, of what is it that you or other opposition would do to improve the situation of those crossing the Channel. I deeply regret those crossing the Channel, and I don't have an answer, but I don't believe the need to stop people crossing the Channel in a dangerous situation is any reason to pass an utterly shocking bill. It's constitutionally incorrect and not looking at genuine victims, such as those victims of modern slavery. And it is no answer to those of us who cannot accept what is going wrong in this country and what is going wrong in this bill, that because we can't offer an answer to the people crossing the Channel, therefore we should be disregarded. My Lords, the victims of modern slavery, one of the most shocking crimes, making vast sums for perpetrators across the world, about probably a third to half of whom come to this country. And quite simply, the government is ignoring the plight of this most vulnerable group of people. And so I do hope they would, at this last moment, just think again about victims of modern slavery.
Yeah. It's a pleasure to follow the noble and learned lady, Lady Butler-Sloss. Before I refer to the amendments in the name of the noble and learned Lord Etherton, I wish to raise a mention of Amendment 25 in the name of my noble friend, Lord Dubbs, and the Lord Bishop of Winchester. Sadly, Lord Dubbs cannot be in his place, but I did raise this issue in another amendment at committee stage, and it is our concern about freedom of religious belief or beliefs and the effect that Rwandan legislation could have on such beliefs, and particularly minority religious beliefs, and the conflict that could arise with the Rwandan blasphemy law. But I'm sure that the Right Reverend Prelate, the Lord Bishop of Winchester, will say more on that. My Lords, I now turn to the amendments in the name of the noble and learned Lord Etherton, and he's made a powerful case for the amendments in his name and others within this group. I have also added my name to those amendments. From second reading onwards, my Lords, we have repeatedly made the case for these amendments. and I will not return to the same arguments, pertinent and important though they are. The government insists that belonging to this particular social group, being LGBT, would pose no threat in Rwanda because there is no discrimination in law. But, my lords, there is no clear protections against discrimination or persecution within law. I refer your lordships to the comments that I made and read into the record from activists in Rwanda who detailed their direct experiences of societal discrimination which directly affect them and their quality of life. To put it in context, my lords, following the genocide, the abiding principle followed by the Rwandan government has been the principle of countering what is known as divisionism, ensuring that groups do not arise and are not pitted one against the other. The genocide informs the approach to governance, and that means, my lord, in effect, conformity. And if you do not conform, it can be represented, and regularly is represented, as created divisionism that would have further consequences and is punishable by law. I give way to the noble lord.
Giving way. The characterisation he asserts as to the mentality in Rwanda does not reflect that of the community representatives whom the JCHR met last week. And it's clear from the evidence that they gave us that Rwanda is very much a leading light in East Africa as to being an open and tolerant home for LGBT plus people. And indeed, it's somewhere that it's very much felt in the region that gay people are at home. And I do not accept the characterisation that he sets out. And I would encourage him to think again about the welcoming nature of the society in Kigali, particularly given what's going on in neighbouring East African states, for example, in Uganda and in the DRC.
The noble lord for that considered intervention. I can only speak according to my experience, my direct experience from 2008 in Rwanda. As I said earlier in discussion of another grouping, I worked within Rwanda for several months as the chief election observer for the 2008 elections. At that point, I had to intercede on behalf of activists who were directly experiencing discrimination. I haven't given up on that. I recognise what is going on in Uganda and other countries, but comparisons are not always helpful. Indeed, they are somewhat odious when it comes to the lived experience of people who I am in direct contact with. This is not academic, I say to the noble lord. What I'm talking about is what is reported to me as he is referring to what was reported to him and other parliamentarians on a parliamentary visit. So, my lords, I therefore, following on from my previous references to divisionism and the consequences caused by one group against another, I therefore assert, my lords, that LGBT people could not live openly because to do so would be a challenge to others and it would not be accepted. Indeed, it would be and could be portrayed as divisionism. This is in direct contrast to the protections that arise from the judgment referred to by the noble and learned Lord Etherton H.J. Iran from the Supreme Court of 2010. And affects characteristics arising from belonging to a particular social group. My lords, again, I refer to the intervention at committee where I represented some of the concerns of LGBT activists, and I will not repeat them again, but if members of your lordship's house request me to do so, I'm more than happy to oblige. At the end of last week, my lords, I again made contact with LGBT activists and asked again, what was the situation like for LGBT asylum seekers in Rwanda? The reply, my lords, was succinct and stark, written in 4 separate messages so that it could not be connected or traced. I quote, "Rwanda is not a safe place for LGBTQ asylum seekers at all." Second line, there are no laws. Third line, community is facing, fourth line, so much violence and discrimination. Starkly put, my lords, Rwanda is not a safe place for LGBTQ asylum seekers at all. Though there are no laws, community is facing so much violence and discrimination. They are not my words, my lords. They are the words of people living there, people in that region. That is the reality of life for LGBTQ people that we send to Rwanda, and sadly not the representations made to visiting parliamentarians.
My Lords, I rise to support Amendment 42, tabled in the name of the noble Baroness Lady Butler-Schloss. My Right Reverend friend, the Bishop of Bristol, regrets that she cannot be in her place today to speak in support of this amendment, which she has signed. The question of deterrence is central to the government's premise in this bill. The threat of being removed to Rwanda should, in theory, be sufficient to discourage asylum seekers from taking dangerous crossings in small boats across the Channel. Even if we accept that this will work, and I have not seen evidence which suggests that it will, but even if we do accept that this will work, for individuals who are trafficked to the UK against their will, how can the bill possibly have a deterrent effect? This point was made repeatedly during committee stage, but has not been adequately addressed. There are as many as 4,000 people in the national referral mechanism who potentially could be eligible for removal. Can we not give them assurance that we will not subject them to further upheaval? The Global Slavery Index estimates that the rate of modern slavery in Rwanda is more than twice as high as the rate in the UK. Can we be sure that victims will be safe from the risk of re-trafficking? The provisions of this bill are incompatible with protective obligations, but potential victims won't even be able to put this injustice to the courts under the Rwanda Treaty. Not identifying victims or sending them to another country before their claim has been properly assessed will also set us back in our efforts to bring perpetrators of modern slavery to justice. Victims are often the only witnesses of the crime. Without them, the case against perpetrators will be significantly harder to make. Safeguarding victims of modern slavery from removal to Rwanda will have a negligible impact on the supposed deterrent effect of this bill, and every effect on the safety and flourishing of the victims of modern slavery.
My Lords, my name would have been to Baroness Butler-Schloss's amendment, but I was not quite agile enough to get in as number 4. The treaty provides at Article 13 that Rwanda shall have regard to information provided about a relocated individual relating to any special needs arising from their being a victim of modern slavery or human trafficking, and shall take all necessary steps to ensure that needs are accommodated. Those are the words. It does occur to me that if the Home Office rushes through its processes, as it will under the legislation of 2022 and 2023, I doubt that individual needs will be adequately identified, because it's hard enough to do even under the pre-2022 procedures. But of course, what Rwanda is told is necessary and what it actually can provide are, as has been covered pretty fully today, not the same necessarily, the same thing. Its record is not exemplary. The 2023, so just last year, US Trafficking in Persons report tells us it did not report referring any victims to the services. That there were none is, to me, literally incredible. The report refers also to widespread cultural prejudice and as we've just heard, along with a lack of capacity and resources which inhibit effective procedures and so on. My Lords, referring to the words of the treaty as if that actually made them happen seems to me to be simply an extension of the argument that the legislation says Rwanda is safe and therefore it is safe. So I ask the Minister what assessment the government has made of the risks of Rwanda being safe in this respect, what assessment it's made of the its capacity to provide services, whether it accepts that Rwanda is able carefully to assess each individual's risk of being re-trafficked. The risk in this country is enough. My goodness, what must it be there? Indeed, what assessment has it made of how it came to be that excuse me, those people who were sent to Rwanda by Israel disappeared? Common sense gives me a likely answer.
Very good. Yeah, my Lords, I rise to speak to Amendment 44 in this group, which is in my name, and supported by the noble and gallant Lords, Lord Stirrup and Lord Houghton of Richmond, and the noble Lord Kerr of Kinlochard. My Lords, before turning further to Amendment 44, I should say that I support the amendments in the name of the noble and learned Lord Etherton, and the amendment in the name of the noble and learned Baroness Butler-Sloss. I have had the benefit of hearing these amendments supported by them in committee and today in your Lordship's House. I don't plan to say anything further, but certainly in relation to those who have been trafficked or are the victims of modern slavery, I cannot for the life of me understand why the government's attitude to such people should be that they were in control of their own decision making when manifestly they were not, and categorise them as such. My Lords, I support also the amendment in the name of the noble Baroness Lady Meacher, the amendments rather 31 and 32, which I'm sure she will speak to immediately after I sit down, and the amendment in the name of my noble friend Lord Dubs, number 25. My Lords, as the explanatory statement in relation to Amendment 44 makes clear, the clause proposed by this amendment would exempt from removal to Rwanda people who are in a very special case. Those who put themselves in harm's way in support of Her Majesty's Armed Forces or through working with or for the UK government overseas, and extends this exemption to their partners and dependents. My Lords, in committee on February the 14th, responding to the debate on this amendment, the noble Lord the Minister said at column 288, and I read this short: "Of course, we greatly value the contribution of those who have supported us in our armed forces overseas, and we have accepted our moral obligation. Anyone eligible for the Afghan Relocations and Assistance Policy and Afghan Citizens Settlement Scheme should apply to come to the UK legally under these routes. As regard the specific case of British Council personnel, they are qualified under the third pathway of the ACRS, and places are offered to them." My Lords, I know and I admire the noble Lord the Minister, and he is correct, but his restatement of the eligibility framework and criteria for these schemes does not engage, never mind undermine, the necessity for this exemption. It's clear that we have a moral duty to those who have served at our behest and in our interests. However, despite serving shoulder to shoulder with British troops, most of the triples were not evacuated in August 2021, and subsequently many have been rejected under the ARAP scheme. We know now that they were rejected because of misunderstandings on the part of decision makers of the terms of ARAP, the nature of the service of the applicants, often despite the existence of compelling evidence to the contrary, And also there is now credible evidence suggesting that UK Special Forces Department blocked eligible applicants from being accepted. They are a group who were refused wrongly by the bureaucracy or blocked for self-serving venal reasons by the special forces of the country, whose government and ministers, out of moral obligation, promised them, and still does promise them, sanctuary. It comes to this. Many applied for the status that would allow them a legal route to resettlement in the UK. They were refused in error. Then, fearing what materialised as their comrades were murdered or tortured by the Taliban, they were faced with the choice to stay in Afghanistan and face certain death, or to get here somehow. They chose to get here somehow. They were in extremis, had no alternative. There was no legal route open to them because of our failures. In committee, my lords, I shared accounts of the experience of 5 Afghans who were driven to this extreme and acted accordingly. I don't intend to repeat them this evening, but they're freely available in open source and media, and I'm sure there are many others that will become apparent over time. Responding to this amendment at committee stage, the Noble Lord the Minister asserted that, and I quote, "Regardless of the contribution they have previously made, a person who chooses to come to the UK illegally, particularly if they have a safe and legal route available to them, should be liable for removal to a safe country." The third clause of that sentence does, I think, make a rather startling admission that the position of this government is that even when they have failed, that is, the government have failed, when access to a safe and legal route is wrongly denied, the consequences of their dereliction should doubly be laid upon those who are already victims of it in the first place. Your Lordship's House is a legislative chamber. Where there is a wrong that can be remedied via legislative means, we are empowered to do just that. Making law is not separate from morality, but in cases of this moral seriousness, should be a means of translating morality into practical, proportionate and enforceable measures. On the 5th of February, in the debate on a UQ on the relocation of Afghan Special Forces, I welcomed, and I repeat that welcome today, the government's undertaking to review all the applications from members of the Afghan Special Forces, known as the Triples, that already have been deemed ineligible. Some of these very brave men and their families and dependents are hiding in Afghanistan, others in Pakistan awaiting whether the new government in Pakistan will deport them back to Afghanistan, where they will be in danger of their lives. As I said then, in addition to those who are in Afghanistan and Pakistan, there are others who are here in the United Kingdom. In August 2021, when Kabul fell to the Taliban and chaos ensued around Kabul airport, they were denied access to evacuation flights. The Taliban in attendance around the airport knew who they are and where they lived, and soon, when the killing of their colleagues and families started, they were forced to get here by irregular and dangerous routes. On the 5th of February, I asked whether the Ministry of Defence, in carrying out the review, would undertake not to make them ineligible for ALAP simply because of how they got here. No such undertaking was given either then or since. Apparently, His Majesty's Government, while greatly valuing the contribution of those who have supported us and our armed forces overseas and accepting their moral obligation to them, nonetheless values the Rwanda policy more. My Lords, the provisions of the Illegal Migration Act are so unambiguous that if any got here with the assistance of traffickers and crossed the channel in small boats, they are illegal migrants. Section 1, subsection 2, paragraph A places a binding duty on the Secretary of State to arrange for their removal. In conjunction with the provisions of this bill, were it to enter into force, that removal would be to Rwanda, and some already have been threatened repeatedly with deportation to Rwanda. It is to remedy this that the amendment is necessary. In this context, I echo a question I asked in committee on 14th February. When we ask others to ally themselves with us in the future, as we will, what lessons do we imagine they will draw from these Arab cases? That we are steadfast in our support for those who have lent their support to us, that we can be trusted to meet our commitments. No, we will be seen as utterly transactional. A power that asks others to risk their lives and pledge themselves to act in our interests, but will not offer sanctuary in return when they need it. As I've said, I welcome the statement from the 1st of February that the MOD has decided to undertake a reassessment of all decisions of ineligibility made on applications with credible links to Afghan specialist units. But evidence of errors in handling eligibility for Afghan settlement schemes is not confined to the Triples and Arab. I refer your Lordships to the evidence compiled by the charity the Sula Alliance, whose spokesperson, Professor Sarah de Jong, has commented that their casework of interpreters and labourers who qualify under the ACRS being treated similarly by decision makers and full of errors. This amendment goes significantly further than the Government's reassessment and meets the moral need. While I do not approve of the bill or its intentions, this amendment should attract support even from those who count themselves among the bill supporters. If they wish the Rwanda scheme to work and be seen to work, this would at least ensure that we do not face the ignominy of seeing those who have risked their lives at our instigation being deported from the country in whose service they have risked exile, serious injury and death.
Having tried earlier in the day during questions to be supportive of the Noble Lord the Minister, let me now seek to redress the balance. I have appended my name to Amendment 44 for two reasons. First, because I regard it as essential that we meet the obligations we have undoubtedly accrued to those who have supported the UK's overseas endeavours in the past. But equally, because we need to protect our ability to garner such support in the future. Support that will be crucial in many instances to the success and safety of our own armed forces. And it is for this reason that faster and better handling of currently outstanding issues, like those pertaining to the Afghans, will not of itself resolve the issue. Now, this bill has passed in another place and will undoubtedly become law. This amendment does not in any substantive way affect the powers and arrangements set out in the bill. It carves out a very limited exemption. Now, the government will undoubtedly argue that the more the exemptions, the weaker the bill. Maybe. But this, it seems to me, is a pretty important exemption. And that really is the question before your Lordships. Would the harm done to the UK by not agreeing this amendment outweigh the impact that agreeing it would have on the government's objective of ceasing illegal immigration? The answer, it seems to me, is an overwhelming yes, and therefore I believe we should agree the amendment. The Noble Lord the Minister will undoubtedly disagree. My proposition to your Lordships is therefore this. Let us pass the amendment and send the issue back to the other place, and let us then see what importance they attach to the safety of those who have hazarded their security and their very lives in support of global Britain's overseas endeavours.
It's an irrefutable case, in my view. It's very odd when you think about it. We've had 3 days in committee. We've had a long second reading debate. And the government have had nothing from us which is of any interest to them. There are no government amendments on the list today, not a single one. And the government has shown no signs of picking up, improving, adjusting, taking advantage of any of the amendments tabled by anyone all around the House. I'm tempted to say it's rather contemptuous. We've taken their bill seriously. I'm not sure that they've taken seriously what we've said about the bill. But now we come to the test, because this particular group contains nothing which would in any way detract from what it is the government are trying to do. And having heard the noble learned Lady Butler-Sloss's explanation of the modern slavery amendment, that it cannot be right to treat the victims of modern slavery as perpetrators. It cannot be right to penalise victims. Having heard the arguments advanced by noble learned Lord Efferton, who has drawn attention to what clearly is a lacuna, not a large lacuna, but a real lacuna,